Yes.
Wait, we just minute. My lord, item number 40 series matter starting from item number 49, my lord.
Yes.
Can it be taken up at 2 p.m., my lord? Conference at secretary. And the plea applies.
No, please. So item number 34, Lordship, it has become infrastructure. That may be closed.
Okay.
That's one question.
Upon instructions, Mr. J. Kalita and counsel for the petitioner submits that the matter has become infructuous. According to this, contempt petition stands closed. So both sides representing. Okay.
Okay.
Yes.
Like, so I like to mention item number 31. After view. Item 31. I'm not a petition.
Okay. You have informed the other side.
I'm not a petition, Lords.
You have informed the other side because AG and additional AG are there. At least you inform them. Then you make a prayer. Correct.
May I please Lordship, I have to mention item number 29, Lordship. We have to file implement petition, Lordship. Lordship, please the matter taken up the
Instruct a due vacation to so as to enable the petitioner to file an impleading application.
Worship, I'd like to mention item number 13.
Yes.
Worship matter will be kindly fixed after 1 week.
Alright, in this matter, item 13.
30.
13.
13. Okay. Okay.
I appear for nearest matter, response 3 to 6.
Yes.
Right, this matter has become infructuous long back. Unnecessarily, it has been pending. That has affected our functioning in the institute.
Okay. Then let it reach. Then let it reach. Once he.
The whole claim was he was released on attaining the age of superannuation at the age of 60. His claim was that he should continue till 62. Now he is about 64 or 65. So there is
Oh, acha. No.
so then what remains in the case?
No, it's okay. We'll take it up.
Market.
We'll consider a prayer when the matter reaches.
Lordship, I have another prayer for item number 40, 42 and 43. Lordship, I have concern on the other side. Lordship, B set 3. Lordship, that matter will be fixed after B vacation, Lordship.
Okay. Both sides are represented on the prayer made by Mr.
As Sutradhar.
S. Sutradhar, counsel for the petitioner. Matter stands adjourned today. Let's not ensuing due vacation 42, 43.
Of the
Okay.
Lordship.
May I please your lordship, in item number 17, we have filed our affidavit in reply today. The same may be brought on record, your lordship. Much obliged.
My lord, in item number 26 and 27, my lord, the order has been complied with. Contempt matter.
Okay, you have informed the other side.
I am for the petitioners. Now.
Oh, acha.
Eliminate the secondary. Eliminate the secondary.
I think this will be elementary.
Yes, yes. Lordship may kindly record my name. Yes, yes.
Okay.
It will.
Mr. D.K. Roy, and counsel for the petitioner submits that the order in reference to the court has been complied with. So Mr. SMT Jistin and counsel for respondent.
1 and 2.
Numbers 1 and 2 is present. Matter since closed as the order has been complied with. 26, 27.
Yes, my 27.
Okay.
Same practice.
Yes.
Yes.
May it please your lordship. Lordship, I beg to mention item number 46 of the daily list.
40.
46. Lordship, my senior, Mr. B. Kaushik is not well today, therefore he could not appear before this court. Lordship, may kindly pass over the matter for the.
You have informed the other side.
No, your lordship.
No, then let the matter reach. No ex parte adjournment.
Much obliged.
For item number 31, let's say.
Yes.
Council. Because they are representing the respondent also.
Okay.
Yes, some difficulties. Yes.
Okay. Both sides are represented on the prayer made by Mr. Ida Karan, counsel for the petitioner. Matter stands adjourned today. List after ensuing due vacation.
Yes, sir. Oblige.
Obliged.
Oblige.
Daily list item number 1 for admission.
Meet with your lordship. Within this matter, the selection of the private respondent, respondent number 9, as a junior assistant in a high school is said.
Yes,
My lord, if you also kindly have a look at the order dated 1st of March 2023, the records were directed to be produced.
We have placed the record.
okay. You give it, will take it when required.
Yes.
Yes,
Well, there was an advertisement for the recruitment of junior assistant in various high schools and higher secondary schools. And the petitioners, they applied for post of junior assistant.
yes,
And eventually, the respondent number 9 has been selected and appointed.
yes,
And his appointment is challenged primarily on the ground that the selection committee was not constituted as per the rules. And there is also allegation of bias. Because one of the members of the selection committee is a son of the father of the he's the son of the president of the governing body, and the selected candidate is his relative. Now, firstly, my lord, your lordship will see, because the records, because primary allegation is that constitution has not been in terms of the rules, and in the RTI application, the reply, your lordship will find at page 16 by the headmistress of the high school. There, my lord, the replies are not very clear. And that's the reason why this court wanted to see the reports,
okay.
original selection reports. May I take your lordship to the rules, my lord? The relevant rules are called Assam Secondary Education Provincialized Service Rules 2003. That's that your lordship will find at page 363 of that book.
Yes,
The rules relevant for determining these issues raised in the petition are Rule 4, 4A1, 4 bracket small a bracket Roman 1, small 1. May I read it, my lord?
yes,
Recruitment to the cadre of lower division assistant under Rule 32A, Roman 2 and +4 post under Rule 32B in the office of the higher secondary and multi-purpose schools shall be made directly by the appointing authority from the select list prepared by the school selection committee. That is important, my lord. Prepared by the school selection committee constituted under the provisions of Rule 8C on the basis of test and interview. Then your lordship may
by the
kindly come
appointing
to Rule
authority from
8.
the select list. That means whoever is appointed is, should be from the select list.
Yes. And the selected list is to be prepared by the school selection committee.
Yes,
And school selection, constitution of the school selection committee is found in Rule 8, sub 4. Rule 8.4. The school selection committee for selection of principal, postgraduate teacher, graduate teacher, and non-teaching staff of the school shall be as follows. Chairman, the president of the managing committee. My lord, my allegation is that the president of the managing committee is not the, my lord, chairman of the selection committee that was constituted. Then the vice principal, postgraduate teacher, in case of higher secondary school, assistant headmaster, so and so, that is, my lord, that has been complied with. One parent to be nominated. Then member secretaries, principal, headmaster of the school. Now there is a, in addition to above, your lordship will find, there shall be a subject expert in case of selection of postgraduate teacher and graduate teacher wherever necessary. There shall be a district approval committee. Then the deputy commissioner of the concerned district or his nominee below the rank of additional deputy, not below the rank of ADC. This all my. So that may not be relevant. Now, what is relevant is, my lord, number one, the president of the managing committee, and your lordship will find that there is no provision of us of an expert so far as the LDA is concerned. These experts are for the selection of postgraduate teacher and graduate teacher. Now, the case of the petitioners is that
No, that is in the office structure, they are the most difficult to tackle.
that's right, my lord. I have experience. I have the experience.
Unless they come to know that you are a lawyer. Things get very difficult.
No, even then, my lord, you go to, that is the pet answer is you go to court. That is the pet answer. And education is number one. The chairman is not the president of the managing committee, and that a computer expert is the son of the president of the managing committee and related to the private respondent. These are the only issues your lordship requires to determine in this matter.
He is the son of the president.
Yes. And the selected candidate is a relation of the president, and that's why the president is not there. Perhaps, my lord. Now, the specific allegation is that the computer expert in the committee, namely Hemanta Pharma, he is running a computer shop whose father is the president of the GB, and the selected candidate is his relative. These are the two allegations, my lord. Only records will reveal that. It's a very narrow compass. If your lordship finds that it has been considered properly, we don't have the case. And
Let me
why
have this stand before I look at the record. I'll hear Mr. Sharma and Dr. Goswami.
Madam, regarding the selection committee, we have filed our affidavit in opposition in page number 16, my lord.
Yes.
It is from headmistress to deputy commissioner, my lord.
Yes.
Here it is stated that with reference to the subject cited, I have the honor to inform you that as per the guidelines issued by the Director of Secondary Education, Guwahati, Assam, a selection committee was formed by Dekargaon High School SMDC on 17/12/2015. The SMDC later formed an empowered selection committee for the said examination comprising of the following members as number one, Mr. Devendra Kumar Bora as president of the committee. Number two, Mrs. Aruna Goswami as member secretary and ex officio member. Number three, Mrs. Rumi Sharma as senior assistant teacher. Number four, Kesaram Bora as guardian minister, guardian member representative. Number five, Hemanta Kumar Sharma as computer expert for examination. So here, my lord, guardian also there, everything is The committee further went to select Mr. Manoj Pradeep Sharma as a suitable candidate for the post of junior assistant after due scrutiny, which was conducted legally by the competent authority held on 22/1/2016. The member secretary of the selection committee stepped forward to submit the relevant documents of the selected candidates before the inspector of school, report, but no sooner than later, the inspector of school informed that an allegation was lost in view of the selection of the candidate for the post, my lord. So the inspector of school himself passed an order to reconduct the examination of the computer knowledge test, computer typing in English and Assamese on Viva Course on 3/2/2016 by selecting Miss Dubori Mohanto as an computer expert in place of Hemanto Kumar Sharma for the said examination under the direct supervision of the inspector of schools and Hemkarna Septi headmaster of Halesar High School, Sonitpur. During the course of second re-examination of the senior assistant teacher, Mrs. Rumi Sharma was replaced by Mrs. Momi Borwa as the earlier has some domestic problems as reported to committee, which was submitted in a written statement to the inspector of schools, Sonitpur, and before the examination. It is noteworthy that the same person, that is Manoj Pradeep Sharma, was selected as per his merit, which was free from any unethical practice and as per stated law. Pradeep Sharma. 9.
Mr. Chaudhary, where is the pleading of your allegations that about the computer expert, he being the relative, where is that?
Paragraph 14 at page 9. In fact, my lord, there was earlier an interview and selection, and there were complaints, and that selection was set aside. In that selection, my lord, the respondent number 9, although in the written examination he stood fourth, after the interview he became first one. Then complaints were made. Then the deputy commissioner directed to hold the interview again.
My lord, computer examination, computer test and viva voce was reconducted, my lord. On 3/2/2016.
There in paragraph 5 also.
In our affidavit, paragraph 6, it is clearly stated, my lord.
The first test was held when?
First, this was held on
16.
2016.
And when was the second one?
Second one is
And my lord, viva voce was held on 22/1/2016, and next viva voce and computer test was held on 33/2/2016, my lord.
3/2/2016.
Yes, my lord.
Yes, Dr. Goswami, what do you have to say?
My lord, in this case, my lord, the selection has been done as per provision of law, my lord. The written test was conducted on 22/1/2016, my lord. And the on 19, my lord, 19/1. And computer test was conducted on 22/1/16. And on 29/1/16, panel of selection list was provided as per their statement, my lord, in the petition. And only after knowing that he was not successful in that exam, he has filed first complaint on 31/26/2016, my lord.
Yes.
First complaint. Annex of type, page 24. Your lordship may kindly go through that complaint. Page 24.
In fact, before proceeding to here, I just forward you the two things. All three of you can live together. Because here, all three of you should be aware what is there.
One more aspect.
Mr. Chaudhary, you can just come this side so that all three of you can.
Another aspect, my lord, the select list, there has been, my lord, annexed to the affidavit, that shows, my lord, only one person has been selected.
Just
There,
come
my
this
lord, two persons are to be.
Now, I have Dr. Goswami, please accommodate Mr. Chaudhary.
Sorry.
There are two yellow flags I have given.
Yes.
This is the select committee. Correct. And now come to the next flag. Yes, here you will find a signature of one Mohanto, who is the expert.
Duburi Mohan.
Yes. Now the case projected is here that on the complaint made by you against Hemanta Sharma, he was removed and the computer expert was substituted by Duburi Mohanto. Now this select list says otherwise. And the evaluation, this signature comes. And what Mr. Sharma was pointing out, page 16. This is again contrary. Page 16 of that affidavit of the government.
That is the letter that in release this deputy commissioner. This is the letter.
I understand this is 16 too, but that Duburi Mohanto is not here.
Yes.
Because you still write.
But my lord, behind, my lord, on last two line, my lord.
No, no.
And
You
the
see,
Baba was
no, that's
on-
what I'm saying. Here and that this committee constituted here
Yes.
doesn't have Duburi Mohanto there.
In fact, my lord, the rules do not provide for an expert.
The first flag, it doesn't have it.
Selection committee has constituted yesterday. Duburi Mohan now.
Kind around 13 November 2015.
Staff secret village manager.
So, pass an order to reconduct the computer test by select.
Yeah, Bishop, take what I get.
So, my lord, after allegation is coming, then my lord, inspector of school himself pass an order. Order to reconduct the examination of computer knowledge test, computer typing in English and Assamese and Bangladesh on 3/2/2016. By selecting Miss Duburi Mohanto as a computer expert in place of Hemanta Kumar Sharma.
So where is that?
The 16, page number.
No, no. Where is that document? Since you have produced the record, where is that document that the expert was substituted by the inspector of schools? Because Mr. Chaudhary, if that can be shown, then because of page 15 of the affidavit in opposition by the respondent authorities, then perhaps you won't have a case. Because here in page 15 of that affidavit in opposition, it is stated that in presence of the supervisor nominated by him, the entire selection process took place.
So there has to be another communication by which the selection committee has been reconstituted. And my lord, the first constitution also does not say why the president of the managing committee is not there instead of, because his name is my lord Bakanta Verma. And the president of the selection committee is Devendra Sondabora. Why he has been, why not the president of the managing committee? That has not been explained anywhere. That is contrary to rules. If they find that my lord, one of the candidates is a relative of the president of the managing committee, that ought to have been there, and on that basis, the reconstitution could have been perhaps made, my lord.
No, you see, because this is something which we do regularly. In course of my job, I have to take interviews. And then if people who are closely known appear, then I recuse myself. We don't have time to change the constitution.
No,
And
here,
therefore-
here it has been constituted by another person, not the managing committee.
No, that is okay. But here also you see the constitution is made by the Honorable Chief Justice. And then suddenly we find that I can't take up the matter. Then therefore I recuse and somebody else joins for that.
So that has to be the approval of the chief justice.
No, it is always post facto because we write that I have recused myself in this case.
Yeah.
And therefore the committee goes and decides the
That has to
matter.
be on the record.
Huh.
The record, whether that is.
If I'm recusing myself in a particular, supposing I'm taking up 15 interviews, out of which one I have been recusing. So I just make a endorsement that for this candidate, I am not there.
That is understandable. But then that approval can be post facto, that is also true, but that has to be there, my lord. And at the initial stage itself, my lord, the selection committee is not in terms of the rules. That is my submission. If, my lord, there is a deviation, that reasons has to be recorded somewhere, may not be in the order, but some other records, it has to be there.
My lord, in this report, Gauri Mohanto's name also there, my lord. In Dekalgaon High School letter, there, my lord.
That letter, you see, that is not official. That is a letter which is given by the by that school.
Yes, ma'am.
Here you are saying that the reconstitution was done by the inspector of schools.
Yes,
In that letter,
yes,
you say that it was done. You see,
Yes.
here you are writing in that page 16,
yes,
computer so and so by selecting Dubari Mohanto as a computer expert in place of Hemanta Kumar Sharma for the said examination under the direct supervision of the so and so. No, before that. So the inspector of school himself passed an order
yes,
to reconduct the examination in computer test so and so
Yes.
by selecting Dubari Mohanto.
yes,
That means there has to be some order.
yes. Thank you.
It is not there, we will interfere.
And so far as the, my lord, the president of the
Mhm,
selection
because-
committee.
Behind you, Mr. Hemanta Sharma is looking at me very questioningly. His eyes are very questioning. Mr. Hemanta Sharma is there, behind there.
Now, this president of the managing committee has no nexus with the school at all, my lord, of the selection committee.
Because
can I answer you?
Dr. Mohanto, sorry, Goswami, in your affidavit as against the allegations, you have not denied that you are not the relative of the
Yes.
chairman of the SMDC.
Still I admit, my lord. Only because of that, my lord, the president was not there.
No, somewhere the stand is that because of his ill health, he was not there.
Yes, yes. My, my lord, allegation is that his son is a relative of the selected
No,
candidate.
I understand, but you see, if the affidavit would have said that because of he is a relative, he is recused, we would have understood. But he doesn't recuse himself because of that. He recuses himself because of illness.
Yes, my lord.
Therefore, there is something wrong. You should have come with clean hands.
That way also he could not have seen the selection committee, my lord. Even in that case also, he could not have,
No, but the stand is, the two stands are different. If I recuse myself because I know someone, I'll record in my, in the statement that I have recused myself because I know someone. I don't say that I have opted out in one, for one case because I'm ill.
my lord, in that case also, my humble submission is that the written examination or the viva was taken, computer taken on 22/1/2016. And he has filed complaint on 31, that means after 7 days, after knowing the result, my lord. As per his statement, my lord.
No, Dr. Goswami, you see, there is, even I have followed a Supreme Court judgment where I say that if a candidate appears in a selection, he admits only to the legality of it, not the illegality of it. So if the constitution itself is wrong, and if it can be demonstrated from the rules that it is, which is unsustainable constitution, then one does not, by appearing in the interview, he does not admit to the illegality.
My lord, at that time, he has not challenged that constitution, my lord. He has challenged only
No,
regarding.
I will know only when I enter. If I enter the room, then I come to know, then I go out after the interview, then somebody tells me that, oh, these are relatives.
Yes, my lord.
Then only I come to know about it.
Sir, appearing in the viva for computer test, he has lodged the complaint. But in that complaint, there is nothing regarding the president matter. Your lordship may kindly go to the annex of 5.
No, but that has been acted upon. Now we
On the
can,
basis of that allegation
that has been
earlier
acted upon and
reconducted.
thereafter the reconstitution.
yes, my lord.
So reconstitution, the document is not there about reconstitution. The order of the inspector schools is not there.
The computer test was held not in that school, in other school, and on the supervision of the headmaster of other school, my lord. It was not taken in the particular school, my lord, Dakargaon High School.
It was taken where?
Facebook High School, my lord. Is in presence of the headmaster of Haleshwar High School. That headmaster's report is there, by the. It was conducted in another school under the supervision of the headmaster of Haleshwar High School. And XRE page 18, my lord. Page 18 in my affidavit.
Then I have missed it somewhere. It is not there. Mr. Sharma.
Yes.
Is, just show me that bunch of paper because I have missed it out. If there was a examination in another school in the presence of the other headmaster.
Yes.
Is it there, Mr. Sharma? Mr. Sharma, is there any memo there? Just a moment. Is there any memo there that the supervisors had signed there? The representative of the inspector of schools and the this Haleshwar, the headmaster of the other schools. Have they signed anywhere? Hemkarna Chhetri, Haleshwar High School. Since I did not notice this, I did not check that part of the record. It's not there. Dr. Goswami, we have to,
Inspector's letter is there, my lord. Inspector's letter.
no, you
stating
see,
everything, my lord.
no, you see, if on top of my head, somebody comes and supervises, but it doesn't sign the memo. It has to be written again. We'll take it up after some time, we'll go through the record after some time. In the meantime, we'll take up another matters. Just wait for some time, let me. do Some other matters.
On this, my lord. That if it is not as per rules, my lord, this election has per rules. Of course, your lordship doesn't require it to.
No.
authority for that.
Education is always better. This bench has many facets. Because Mr. Chaudhary, the benefit of reading when you are arguing is something else. And when I alone read it without any assistance, half of the thing we can't understand.
That's.
We waste our time reading papers, but the real understanding comes only when elaborate arguments are made in the bar
Will come after some time.
after some time. Yes, Mr. Sharma.
This is a matter where in the year 2018, there was a move from the education department that a particular course called Diploma in Elementary Education would be essential for all untrained teachers under the elementary education. Now, there was a particular controversy at that point of time, because though there was a circular initially that it will be required for all teachers, but there was an amendment. Addendum was there at page 24, which categorically stated that for teachers who were appointed prior to 3/9/2001, this particular course, they did not undergo this course. But then it was followed up by one letter at page 27 by the Director of Elementary Education, wherein it stated that all untrained teachers designated in elementary education has to obtain the ELET course. Now, there was a situation when these particular teachers were asked by the relevant superiors to go for admission at that point of time, 2018. So therefore, we had to approach this honorable court. This honorable court protected us. Honorable court stated everything and stated no pursuit action to be taken. Now in 2023, government has not filed an affidavit. My understanding today would be, I think it is not necessary. And probably the government will be also subscribing to my views. So if that
No,
stands
but you
up-
see, this NCT guidelines will always prevail. Whatever the view is taken by the respondent.
Yes, Lord.
Still that NCT guidelines will prevail.
The NCT guideline itself categorically states that for teachers who were appointed prior to 3/9/2021, it will not be applicable.
No, it says that they have to undergo that course.
No, for
Where is
teachers
that?
prior.
That has not been attached to the repetition, my lord. It is available on the 3rd of August 2010.
From
Yes.
that.
I think the law as it stands today is not necessary for teachers prior to 3/9/2020.
I think they will have to undergo the course. That is what I remember.
The teachers appointed prior to 3rd of September 2001. That I have given, my lord. Clause 3, just
Training to be undergone.
training to be undergone. Thereafter, my lord, lordship will find the teachers
The
appointed
D-
prior to the appointed date.
Teachers
the last
appointed
clause.
prior to that, they need not acquire the minimum qualifications stated in para 1 above.
My lord. So that para 1 above contains the DLED qualification. And at the end of the, my lord, the last of the clauses of that, last subclause of that clause.
Provided that teacher of class so and so.
Below that. 3rd September it is. Teachers appointed prior to 3rd of September. 2001 need
Appointed
not,
before so and so in accordance with the prevalent rules.
need not acquire it.
Teacher appointed before date of notification. Okay, so 3 is again qualified by 4.
Yes.
4 says not required.
Not required.
Then we
So my lord, what I was telling him, I'm going to say that it is an writ petition filed on apprehension only.
No, it was not. an
There was no
application at that
action
point of
initiated
time.
against them at any point of time. Only letter that say, the letter only says that those who are serving need to register themselves and get the
I don't know,
qualification.
some wise man has said prevention is better than cure.
Page 27
You
letter.
have this notification, my lord, I do not think they can be proceeded against in any manner.
Then I close this matter.
That,
because-
that observation,
That's why we will like to refer to the notification. Since prior to 3rd of September, it is not necessary.
Heard. Mr. A. Sharma and counsel for the petitioners. And Mr. R. Mazumdar Leonard. Standing counsel for the secondary education department, appearing for both the respondents. Next. Where is a statement here that you are appointed before
yes, Lord.
this cutoff date?
Yes,
Where is that?
Page 17, para 13.
Page
17, para 13. There are some teachers who joined after, Lordship would have page 15, para H. There are some teachers who are beyond the date.
then there would be some inquiry by
Yes,
the
Lord.
authorities.
Constable give a common observation regarding the position of law, and there will be an
I will
inquiry
just
as to
point
whether
out
they
two things.
qualify under that particular.
The students when I pointed from the petition, that will dispose of. Page 24, madam. Page 24 of the writ petition. First paragraph. In continuation of government notification number so and so issued on 1917, this is for information of all concerned at the National Council of Teacher Education. White letter number so and so dated 28/8/2017 received from MHRD on 5/9/17 has clarified that as per para 4C of the notification dated 23/8/10 with respect to determination of the qualification of teachers to be appointed in schools, this will not be applicable to teachers appointed before 3/9/2001. Now, Lordship may like to have page 27. This is where the secondary education department. First para, drawing your attention to the subject and reference cited above, I am to inform you that all elementary level in-service untrained teachers teaching in class 1 to 8 in government aided, non-government educational institutions appointed on and from 3/9/2001 are to be registered their names in the NIS portal on or before 15/9/2017. Now, if Lordship has page 12.
Yes,
Page 12, my lord, from para B onwards, the different date of joining are given. And lordship will find at page 14. Oh, sorry, page 15. Para H.
cutoff date is 3/9/2001.
3/9/2001.
3/9/2001.
That is the cutoff date. Now, if we have page 14, my lord, para G. Fourth line from the top.
No, just a minute. Yes, G.
Page 14, para G. Fourth, third line from the
Yes,
So let's hold
6/11/2001.
my lord, 6/11/2001.
Yes,
He is beyond that date. Then lordship will have page 15, para H. 5/9/2001.
no,
these are the dates of
even in G,
My lord, yes.
19 is 6/11/2001.
Yes, my lord.
20 is 6/9/2001. 21 is 5/9/2001.
These are all beyond the 3/9/2013.
22 is 5/9. Yes,
Now lordship will again kindly come back to page 27. Those who were appointed beyond 3/9/2001 are to be registered their names in the NIS portal on or before 15/9/2017. This repetition is filed in the year 2018 with a statement that all were appointed before 3/9/2001. There is a misgender of cause of action, those who were appointed prior and later,
after so long, we will not disturb for that.
my lord. But those who were
Okay.
appointed, my lord, what I had pointed out is the date of joining of those persons. The date of appointment has to be seen. Because the circulars talk of the date of appointment. Date of joining may be 1 day or 2 days later. We have seen, my lord, 5/3, 6/3. They are 1 or 2 days later. Those who were appointed prior to that particular date will only have the relief, my lord. The rest have to undergo the DLA training.
My instructions was that they were appointed prior to date. But then the joining that I have clarified, I have written in the particular petition itself, that joining was maybe 1 day or 2 ahead of that for these 3 or 4 petitioners. But this is the joining date.
That I am considering, my lord. If the date of appointment is prior, they will
I-
not be.
Those appointment letters they didn't have, but the instruction was that they were appointed prior to that. The joining was 2-3 days after that particular cutoff date.
How do we go? Mr. A. Sharma, for the petitioner, Mr. R. Mazumdar, standing out for the Secondary Education Department, appearing for both the respondents. The petitioners claim that in course of their service, comma, by virtue of a notification published in the
This is 1/9/2017.
no, it comes from the NCT notification. Then
The first original NCT notification was 3rd of September 2001. Where DLR was made a condition. 2010 got in a little amendment.
where is that 2001?
2001
In
In
course
fact,
of the service,
2010 is of importance because
it
although
exempts.
to-
It
but then
exempts.
Right to Education Act came and then the MHRD notification came, giving the NCT the power to lay down the qualifications.
In course of their service. Notification dated 3/9/2001 was issued by the
National Council for Teacher Education.
National Council for Teacher Education within bracket NCTE, requiring the teachers in the secondary education,
Elementary education.
Huh?
The LP schools, madam,
Acha,
the primary
okay.
section was there.
elementary education. What is it called? LP UP.
LPUP.
Within bracket LP of the UP classes to undergo D full stop elementary education EL full stop ED program. Which was made mandatory for all teachers teaching at elementary level. Full stop. Subsequently, this was followed by another notification dated 23/8/2010. After enactment of the Right of Children to Free and Compulsory Education Act, 2009, which was published in the Official Gazette. And under the under clause 4 of the said notification, the teachers appointed before the date of this the said notification and appointed for classes 1 to 8 were exempted from acquiring the minimum qualification of D.Ed within brackets special education or B.Ed within brackets special education. However, providing that the teacher appointed before 3/9/2001 were in accordance with the prevalent recruitment rules. So this was also followed by another government notification dated 5/9/2017. Where is that? 5/9/17?
Page 24.
Issued by the Elementary Education Department from a government of Assam. Again clarifying that the qualification as required under the NCT notification for having DL.Ed qualification will not be applicable to teachers appointed before 3/9/2001. It is projected that in the meanwhile, the petitioners had registered themselves for acquiring DL.Ed qualification. Full stop. On the ground that the petitioners are exempted from undergoing the DL.Ed course. The present rate petition has been filed under Article 226 of the Constitution of India. For a direction to the respondent authorities to exempt the petitioners from undergoing the course under the DL.Ed program in terms of the addendum dated 5/9/2017 issued by the Elementary Education Department of the Government of Assam. Next, the Honorable Counsel to the petitioners has submitted that this court by an order dated 9/3, interim order dated 9/3/2018. Taking note of the apprehension expressed by the petitioners, directed that no coercive action be taken against the petitioners for not having the qualification of DL.Ed. Next paragraph. The Learned Standing Counsel for the Elementary Education Department has produced a copy of the notification dated 23/8/2010. For clarifying that while teachers appointed before 3/9/2001 were not required to obtain minimum qualification of D.Ed within bracket special education or B.Ed within bracket special education, if their appointment prior to 3/9/2001 was in accordance with the prevalent recruitment rules. So the Learned Standing Counsel also accepts that while addendum dated 5/9/2017, if the teachers were appointed prior to 3/9/2001 in accordance with the prevalent recruitment rules, they are not required to undergo the DL.Ed program. So it is, however, something that the respondent authorities are required to examine if the petitioners were appointed prior to the said date. to set cutoff date of 3/9/2001. In view of the disclosure made by the petitioners that few of them have joined their service after 3/9/2001. Next slide. Having noted that the respondent authorities do not dispute that teachers appointed by elementary teachers in LP of the UP schools who were appointed prior to 3/9/2001 in accordance with the prevalent recruitment rules were not required to undergo DL-Ed program. The court is of the considered opinion that there is no ground for the petitioners to apprehend that the respondents may take coercive action against them. Next, however, comma, as the requirement made by the addendum dated 5/9/2017 issued by the Elementary Education Department, as well as the NCT notification dated that
29/2006. 29/2006.
uh,
29/2006. 29. Password is 29/2006.
29.
2006. 2006.
Okay.
No longer remains a password now.
No, you see, I have a personal feeling that the locks are meant for good people.
Correct. Those who have to break it will obviously break
You
it.
obviously take it, whether you have a password or not.
Yes.
And I have been, I have attended a ethical hacking, what do you call, program, where the expert, he asked me to switch off the mobile, and then he made it ring.
Ring.
Made it ring. Switch off mobile rang. And he says that whether you put off your what do you call ringer off or on, doesn't matter. It can be hacked. System can be hacked. So it was held in IIT long years back.
SIM cards are also cloned nowadays. Same SIM card.
So
being
that's why I
used by
said that
someone else.
locks are meant for good people. And never intended for bad people. The NCT notification dated 23/8/2010. So therefore, the court is of the considered opinion that the authorities in the Elementary Education Department would have a right to undertake the exercise to find out whether the petitioners had actually issued appointment orders prior to 3/9/2001. before accepting the contention of the petitioners for their exemption from undergoing DLED program. Accordingly, subject to permitting the elementary education department to verify the appointment orders of the petitioners, and not the petition stands disposed of by making the interim order absolute.
I'm obliged. Obliged.
You take back your. Number 3.
Wait, please, your lordship. Well, as per direction of this court, my lord,
You produce the documents.
my lord, petitioner went there, my lord. My lord, what happened, my lord? The petitioner came to know that the inspector school, officer of the inspector school had lost the original size book of petitioner's father's time.
Pardon me, I did not get it. Can you repeat again?
They had lost the service book of the petitioner's father, my lord. Now they are pressing the petitioner to file a police report, my lord. However,
Yes,
petitioner
yeah.
had
Can you get the information?
Lordship, you first look into the date of birth certificate submitted by the petitioner. Annexer 15 of Annexer D page 15. In this particular
Just-
case,
just
my lord,
one,
three
just one.
date of birth certificate of the petitioner is produced, my lord.
Just a moment.
Annexer D page 15 of the petition.
Yes,
His date of birth, her date of birth is 23/10/1996.
just a moment. Yes,
Then lordship will look into the IA filed by the respond number or FTP in opposition filed by the respond number 7, my lord.
affidavit in opposition by
Filed by the
respondent
respond
7.
number 7.
Yes,
My lord. Annexer 4, page 10, my lord. Annexer 4, page 14. Affidavit in opposition filed by the respond number 7.
page 14.
Annexer 4, page 14.
No, annexure 4, this is annexure 5.
Affidavit in opposition filed by the respond number 7.
Yes, annexure 5 is a birth certificate. 4. Page,
4.
this is page 13 in my copy.
My lord, date of birth is 3/12/2003.
3/12/2003.
Then my lord, lordship, we annexer 5, another date of birth certificate. Page 16,
In my copy it is 15.
my lord.
Yes,
9/12/1995.
okay.
Now, so the petitioner has to clarify that what is her date of birth, first, my lord. Second, my lord, the headmaster submitted a report that when he joined in the school, my lord, service book is not with him, my lord. So to produce the service book, my lord, the petitioner has the service book. He has the annexed copy of the service book is with him, which is the annexer A page 11. As the petitioner has annexed the copy of the certified service book here, my lord, he can easily produce the certified posted copy of that so that the inspector of school can produce the certified my lord, duplicate service book, my lord. Now, if the petitioner says that he does not have the service book, how he can produce it before this honorable court as annexer A page 11?
No, because service book, he will not be getting it.
My
He
lord,
may have a copy.
my lord, copy, the photostat copy, if he furnish the photostat copy to the my lord, inspector of schools also, then he can make a my lord, duplicate copy. But that has not been produced by him, my lord. And the headmaster submitted the report to the inspector of schools that when he joined in as inspector of schools, in that he could not find the service book of the petitioner, my lord, or father of the petitioner. So that is the difficulty, my lord. My lord, it is the case of pension, my lord. If the petitioner is entitled, if he cooperate with the inspector of schools, definitely will, my lord, will process it and submit it to the, my lord, will forward it to the director of pension. That is only our rule. But he has to clarify first that what is his date of birth, my lord. The date of birth is the,
And there are things I can't understand here. There is a different date of marriage also.
my lord, their respondent 7 is there. There are two claims, my lord, petitioner and the, my lord, second wife of the father of the petitioner. So that was the dispute, my lord, initially.
Okay,
And subsequently, the brother of the petitioner submitted the application that the respondent number 7 died. But the death certificate, the husband of the name of the disease is different. So all these things are clumsies are there. They have to, petitioner can only clarify. The respondent number 7, he appeared before this court, filed the affidavit, annexing all the documents. Now the petitioner submitted before verbal information to the inspector of schools that the respondent number 7 died and submitted a death certificate. In the death certificate, name of the husband of the disease is different.
where is that?
But he has not annexed all those things. He has not submitted a reply, our affidavit in opposition. He can bring it to the notice of the honorable court also, but
No,
filing all
where,
these things.
where is your affidavit? You have said that she died. that
My
she-
lord, I have,
Yes,
my lord, lordship will look into, my lord, our affidavit. Page 6, my lord. We have stated all these things, my lord. Page 6, page 4, para 6. The brief facts of the case is that late Chaityadev Sohan was an assistant teacher of Adarsha Rastrabas High School, Nawali, Karbi Anglong, Adarsha
Just
Rastrabas High
just
School,
now, just now, I'm not, affidavit in opposition of,
Advent Inspector of Schools, my lord, on 29/11/2022.
yes,
Page
para,
4, para 6.
yes.
The brief facts of the case is that late Chaityadev Sohan was an assistant teacher of Adarsha Rastrabasa High School, Karbi Anglong. Adarsha Rastrabasa High School only was provincialized with effect from 1/2/1991 by the order dated 4/3/1991. Chaityadev Sohan died on 22/1/2016. After his death, the petitioner, Ms. Sunita Kumari, daughter of the deceased late Chaityadev Sohan, and Srimati Asa Devi, the respondent number 7, the second wife of the deceased, both separately claimed for retirement benefits and family pension of the deceased, submitting different next of kin certificates. The petitioner, being the daughter of the deceased, submitted the next of kin certificate issued on 8/4/2016 by the Deputy Commissioner, West Karbi Anglong, Amren. The respondent number 7, being the widow of the deceased, initially submitted the next kin of certificate issued on 11/7/2016, which was subsequently cancelled by the Deputy Commissioner, Karbi Anglong Depot. The respondent number 7 thereafter submitted another next of kin certificate issued on 4/4/2017 by the Deputy Commissioner, West Karbi Anglong, Hamrel, in which both the petitioner and the respondent number 7 are included as next of kin, along with the petitioner's brother, Sri Pramod Kumar Sohan. Both the petitioner and respondent number 7 separately claim to be the legitimate heir of the deceased. As such, both the petitioner and respondent number 7 were asked to produce the succession certificate. But due to non-furnishing the succession certificate, the deponent could not take the decision in respect of payment of the retirement benefits and other family pension of the deceased. That the headmaster of Suenshu School, by his letter dated 11/11/2022, informed the deponent that the respondent number 7 died on 23/7/2022, and the death certificate of Asa Devi was submitted before him by the brother of the petitioner, in which the name of the husband of the respondent number 7 is mentioned as Prithviraj Sohan, not Chaityadev Sohan. On receipt of the letter dated 11/11/2022, the deponent wrote to the petitioner by his letter dated Suenshu to submit all the relevant documents for processing the pension papers, but the petitioner has not yet submitted all the relevant documents to the deponent for sending the pension papers to the competent authority for sanction of the pension of the and other retirement benefits. As the petitioner has submitted different date of certificate, so she has to submit an, my lord, affidavit also that what is his date of birth, my lord, so that it can be processed. The only the, my lord, unmarried minor daughter is entitled for family pension. Petitioner has not stated in the repetition that she is an unmarried daughter, so she has to submit an affidavit. She has not yet married. In 2015, my lord, the rule was amended that unmarried daughter up to the age of 21 years, my lord, they can, my lord, get the family pension. And in 2018, that rule was again amended that unmarried daughter can get the pension, my lord. So it is the responsibility of the petitioner to submit the affidavit and all other documents.
No, that has also gone because by now there is a judgment of this court where it says that unmarried daughter, there can't be a distinction between married daughter and unmarried daughter.
My lord, but they have to, my lord, submit all those documents before the, my lord, the respondent, my lord, inspector of schools regarding
Mr. Hawk,
clarification.
if you have more than one certificate and you have what you call the death certificate with different names, you will relegate you to go to the civil court and have the matter decided. In the writ court will not decide this matter. This is an inquiry we can't make. And the inquiry which we can't make, I don't think we can relegate it to the responding authorities to also investigate. If there are 3 birth certificates, death certificate with the different husband's name. It's something which the court should not interfere.
Hello. In this case, my lord, there was something issue was going on, my lord. Initially, my lord, the respondent was 7 is mentioning, my lord. To that effect, my lord, initially she was represented by or Mr. I have forgotten the name of the council, my lord. He was representing, my lord. But when he came to know that the respondent 7 already died, my lord, he used to, my lord.
No, the question is which respondent number 7 died?
My lord,
This-
Asa Devi, my lord.
No, but the husband name is different.
Yes, my lord, that is kindly now, my lord, the council has said that the respondent somebody is a wife, my lord, of the petitioner's father, my lord. Now to that effect, my lord.
No, you see, why is there's something are very strange. You are fighting with the respondent number 7. Your brother comes and gives a certificate. That inquiry they'll possibly not be able to do.
Ultimately,
Somebody appears here for a lady, then she stops appearing. The fact that somebody has died under order 22 rule 10A, it is only the appearing counsel who can say whether the client has died or not.
well, that is why, my lord. If, my lord, initially while that death certificate was produced, my lord, the council of the respondent 7, my lord, he was there, my lord. And while he came to know that he was verified, and while he came to know that the respondent 7 already died, my lord, he used to stop appearing, my lord.
No, you see, somebody may have a notion, but if A is the father of B, and in the certificate, the father of B is shown as Z, we can't presume that he has died.
My lord, in that case, my lord, the respondent, the council of the respondent number 7 by obtain instruction also, my lord.
No, if he's not there, I can't go and give him invitation card.
That is why, my
You
lord,
expect me to go
like,
to his
he was
home,
he was initially
invite
appearing,
him
my lord,
with the invitation
my
card,
lord,
come to court.
he had submitted his affidavit in reply, my lord. And thereafter we had filed to the reply also, my lord.
No, in the affidavit in reply, has he
Affidavit
shown the
opposition,
husband
my
name to be different?
Affidavit in opposition, my lord, he had filed, my lord. The which,
Has he shown the name, father's, husband's name to be Prithviraj Chauhan?
yes, my lord. Actually, that his father, that lady, my lord, Asa Devi, his husband name was Peter Chauhan, my lord. And I had clarified with my affidavit in opposition, my lord. Sorry, affidavit in reply, my lord.
If in the opposition, it has been stated wife of late Satyadev Chauhan.
Satyadev Chauhan.
And
kindly see the affidavit in reply, my lord. I had clarified that, what he was going on, my lord.
no, that inquiry you do it in the civil court. I can't decide this. As a writ court, I can't decide this contentious issues. But
My lord,
Mr.
may I allow to, my lord, intimate the earlier engaged council, my lord?
No, we'll close it. Even if the council comes and says we can't entertain that dispute. husband name is different, father's name is different, age of
No,
birth are
I am-
different.
I am not for the respondent number 7, my lord. My father's name, all three is same, my lord. My father's name is Satyajit Chauhan. I am the daughter, my lord.
It's okay. I don't.
I am the
entertain.
daughter. I am, my lord, Sunita Kumari. I am the daughter, my lord. I
No,
am,
Mr. Hawk, you are not entertaining.
my lord, otherwise, my lord, it will cost prejudice, my lord. 2018. my
I'll give you
lord,
liberty. I'll give you liberty. You
To
can go to
approach me
the.
as well, we'll do it, my lord. If he submits all the documents,
My
my
lord,
lord, we'll do it, my lord. There is
my
no
lord,
bar,
that
my lord,
submission
on
may
that.
can record it as I'll submit, my lord. The photostat copy of the
I
submission.
got it. I got it. And Mr. S. Hawk, and counsel for the petitioner. And Mr. J. Chutial, and standing counsel for the Karbi Anglong Autonomous Council. Appearing for respondent numbers 1 to 6. None appears on call for the respondent number 7.
There's one number 3, my lord, 3, 5, and 6.
3, 5, and 6.
6.
Okay, 3, 5, and 6. And secondary education department, Mr. Sharma, you're there.
Sure.
Mr. U. Sharma, and it's standing counsel for the secondary education department, appearing for respondent number 1. And this director of pension, Mr. Bakrel, you look here. Mr. G. Bakrel and a government advocate appears for the director of pension, respondent number 4. Next, by filing this petition under Article 226 of the Constitution of India, the petitioner has prayed for a direction upon the respondent authorities to take immediate steps for releasing the legitimate family pension with effect from 23/1/2016, along with other retirement benefits like leave salary, GIS, GPF, in respect of her deceased father, namely late Satyadev Chauhan. First of all, the learned counsel for the petitioner has submitted that her father, late Satyadev Chauhan, was appointed as an assistant teacher at Adarsha Rashtra Bhasha High School on 15/4/1984, and that his service was provincialized with effect from 1/2/1991. While serving as assistant teacher, the father of the petitioner died in harness on 22/1/2016. Initially, the brother of the petitioner had approached the inspector of schools, Difu, as well as the headmaster of the Adarsha Rashtra Bhasha High School for obtaining retirement benefits. No, it's not retirement benefit, it will be
Pension.
family pension. And other benefits like career salary, GP, GIS, etc. But as such, receivables were not sanctioned for the petitioner, claiming to be a unmarried daughter of late Satyadev Chauhan, has filed this petition claiming family pension and other retired benefits, other service benefits of the against her late father. It is also submitted that pursuant to the order of this court dated 1/2/2023, the petitioner had approached the Office of Inspector of Schools, Difu, it is submitted that although the petitioner had gone to the office of the Inspector of Schools, Difu, But she came to know that the school authorities had who has the service book?
In the respective school, my lord, in that particular headmaster of the school informed.
Okay. The
Service book not
concerned
been
school,
portable.
that from the concerned school, the service book of the of her father had been misplaced or been lost. So it is submitted that the petitioner was asked to file an FIR about the loss of service book. And in this connection, it is submitted that as the petitioner was not the custodian of the service book of her deceased father, but she had not filed an FIR for the loss of the service book. It is also submitted that the respondent number 7 had claimed herself to the wife of late Satyadev Chauhan, and I'm coming to know that the respondent number 7 had also is also claiming family pension and other receivables against her father. The respondent number 7 was implemented by an order dated 26/11/2018. And she contested the writ petition by filing an affidavit in opposition. Mr. However, in course of the proceeding, the respondent number 7 has expired. And the learned counsel for the respondent number 7 on coming to know that the respondent number 7 has expired, had stopped appearing in the matter. Next paragraph. The learned standing counsel for the Karbi Anglong Autonomous Council has referred to the statements made in the affidavit in opposition and has submitted that in this case, the petitioner in a writ petition has produced a birth certificate disclosing her age to be 23/10/1996. Whereas in the affidavit in opposition, of respondent number 7, correct?
Annex of 4, page 14.
This is 7, 2 birth certificates have been annexed to disclose the age of date of birth of the petitioner is 3/12/2003 and 9/12/1995 respectively.
And the petitioner submitted the registration certificate of the school, my lord, not birth certificate.
Registration, school certificate,
School certificate.
not birth certificate. Disclosing the age of the date of birth as so and so. It is also submitted that both the petitioner as well as the respondent number 7 had separately claimed the financial the death benefit and family pension of the deceased with other receivables. So, however, the petitioner had submitted a next of kin certificate issued on 8/4/2016 by the Deputy Commissioner, West Karbi Anglong, Hamren. And the respondent number 7 also submitted a next of kin certificate issued on 11/7/2016, showing her to be the widow of the deceased. So, however, the subsequent certificate dated 11/7/2016 was cancelled by the Deputy Commissioner Karbi Anglong Difu. And thereafter, the respondent number 7 submitted another next of kin certificate issued on 4/4/2017 by the Deputy Commissioner West Karbi Anglong Hamren, in which both the petitioner as well as respondent number 7 are shown to be the next of kin, along with the brother of the petitioner, namely Pramod Kumar Chauhan, as both the petitioner as well as respondent number 7 were separately claiming to be the legitimate heir of the deceased late Satyadeva Chauhan. Both of them were asked to produce a succession certificate, which was not furnished. Next, it is also submitted that by a letter dated 11/11/2022, the headmaster of Adarsh Rashtrabhasha High School had informed the inspector of schools, Karbi Anglong Difu, that the brother of the petitioner had produced a death certificate of respondent number 7, showing her to have died on 23/7/2022. However, in the said certificate, the name of the husband of respondent number 7 is mentioned as Prithviraj Chauhan, Prithiraj Chauhan, Chouhan. First off, accordingly, the inspector of schools had written to the petitioner on 11/11/2022 to submit all the relevant papers for processing the pension papers, but as documents had not been submitted, the pension papers could not be processed and sent to the competent authority. Next paragraph. In the present case in hand, the court finds that not only the service book of the petitioner is reportedly lost, but the materials available in this case discloses 3 different dates of birth of the petitioner, as already indicated above. First, the brother of the petitioner has produced a death certificate of respondent number 7, showing a different husband's name. First, taking note of the fact that the petitioner as well as respondent number 7 had all throughout been contesting their respective claim of financial benefits, including family pension, and other benefits like GIS, etc. claiming to be the legal heir of late Satyadev Chauhan, from a production of a death certificate of respondent number 7 with a different husband's name is indicative of the fact that the dispute and of the claim towards benefit arising out of death of late Satyadev Chauhan is not one which can be adjudicated effectively in a writ petition under Article 226 of the Constitution of India, as the facts itself are disputed. Therefore, court is inclined to close this writ petition in view of the disputed facts which has emerged in course of pleadings. Full stop. Next paragraph. Accordingly, the court is inclined to grant two options to the petitioner. Firstly, to approach the competent court having jurisdiction, either to have a declaration in her favor or to obtain a succession certificate, whichever desired. And the second option to the petitioner is to approach the Office of the Inspector of Schools, Karbi Anglong Autonomous Council, Difu.
Karbi Anglong District Circle, Difu.
Karbi
Inspector
Anglong,
of Schools, Karbi Anglong District Circle.
it's a district circle, Difu. And produce all the relevant documents as may be required to enable the said authority to arrive at a decision. Next paragraph.
The petitioner
However,
agrees that he will,
However, it is also provided that if the,
the petitioner agrees that he will provide the service book.
If the-
If it is provided for
it's
the
okay, if the petition, if the inspector of school finds that the concerned Adarsh Rashtrabhasha English, Rashtrabhasha High School, Nawai Bill, NAWAIBIL, Karbi Anglong, has lost the service book of the father of the petitioner, comma. He would direct the headmaster of the school to lodge an FIR if the said document is lost from the school custody. And he may also call upon the petitioner to produce a copy of the
Which he agrees by.
service book, which is annexed to the writ petition, so as to enable the said authority to
Reproduce it. Reproduce the service.
reproduce the copy of the service book annexed to the writ petition, so as to enable the said authority to
Right.
take an appropriate decision thereon. Let it take an appropriate decision on the claim of the petitioner vis-a-vis respondent number 7 for the entitlements like family pension, comma. What are the other things? GIS, CIS,
Yes.
GPS, leave salary,
Leave
GIS,
salary.
GPF, leave salary, etc.
be slow so that I can, you can write one by one,
Family pension including,
including,
including GPF, GIS, leave salary,
G,
etc.
don't be so fast. She'll have to take a dictation.
Sorry, my lord. GIS, my lord, GPF, leave salary, etc.
Leave secretary, etc. First, having noted that, next para, having noted that this petition is pending since 28/3/2018, comma, in the event the petitioner approaches the Inspector of Schools, the said authority shall expeditiously deal with the matter within the outer period of 3 months.
3 months, sir.
So how the said time limit would not apply. The petitioner approaches the competent court for appropriate relief. The petition stands closed. Observation will be negated above. I'll take a break and come back.
Or. Yeah, Mr. Lordship. My lord, this is petition regarding claiming of the pensionary and my lord retirement benefit, my lord, of the deceased employee, my lord, by the petitioner, my lord. And the petitioner is the first wife, my lord.
Yeah, my lord, I'm appearing for the respondent 1 to 4. My lord, we have been made parties, my lordship, on the last occasion, lordship. Here we are awaiting our instructions, lordship.
No, but you see, there should be a standard, what you call, response by the state, you
My
know.
lord, on the last occasion, if your lordship checks the
No,
last
no,
order,
that is
53,
okay.
my
No,
lord.
that is okay.
My
But you see, in pension matters, if there is one wife or two
My lord.
wives or counter claims, you should have a standard reply ready. Because you see, you have a policy. Either you accept the claim of, if there are two wives, you accept the claim. Or you have a stand saying that only one will withdraw and the others will share it. Or something like that sort. They should have a standard reply in this matters. Why it should be delayed? But I'll give you time since you are implicated on the last occasion. But Mr. Bhagwati, what is your stand?
Lordship, the Millie pension as of such, Lordship, the second wife do not have a claim, Lordship. But Lordship, regarding the personal things of the that employee, Lordship, certain things are personal to him, Lordship. Those they are entitled, children are entitled, Lordship. Children of the second wife, Lordship.
So have you, both of you arrived at a consensus? What can be?
Lordship, that we have arrived, Lordship, that I told him also. And if he agrees, Lordship can.
Yes.
My lord, being a first wife, my lord, I am entitled for the pensionary benefit. Only thing is that, my lord, the daughters, my lord, I think they will, my lord, entitled for the DCRZ amount, my lord.
Equally, Lordship. That is,
Share, my
that
lord.
is.
And what about the, if the person has given a nominee, then what happens? Has the employee given a nominee? No.
Lordship, nominee, I think it was given to the second wife only, Lordship.
To
I'm
second
not
wife.
very clear, Lordship.
Okay. This, here again, there is a succession certificate.
Yes, my lord.
What is the stand in the succession certificate, Mr. Bhagwati?
So, Lordship, both of them have produced their own succession certificate, Lordship. Lordship, mine is at page 20, Lordship. Legal aid certificate, Lordship. That is the
Page 20
page 20, Lordship,
of your affidavit.
of my affidavit.
Respond number 6.
Lordship,
That's one of the.
there are 3 daughters, Lordship. Married and major, Lordship.
Okay. So this.
Lordship, I may be granted some time, Lordship. There is a family court order, Lordship.
Page
Lordship,
14,
if,
page
uh,
14. Page 14.
Page
My lord,
14.
family court order is
There was a
regarding maintenance,
divorce,
my lord. Earlier, my lord, petitioner, my lord, claim for my lord, maintenance.
There was a
That was allowed by the family court, my lord. And
Okay.
accordingly, the department has deducted that amount from the salary of the deceased employee.
You have a copy of that order? Is it,
Yes,
this,
my lord.
this is filed in the affidavit in reply?
Yes, my lord.
Yes. What does it say?
My lord, here in the judgment, my lord, it is already admitted by the husband that yes, petitioner is the first wife, my lord.
In this order?
Yes, my lord.
divorce. Whether they were divorced, Lordship,
No,
that also I am not sure, Lordship.
No, the divorce was not there because in page 77,
yes, my lord. Yes,
uh,
second wife.
the second para says the quarrel took place and she left.
Yes.
In fact, Lordship, she left when he was not employed, Lordship. She left when he was not employed. He was a daily wage laborer, Lordship, and she left with her brother.
No, she may have left, but the status of the, unless there was a divorce,
Lordship, that
The
thing
first
I'm
marriage-
not sure, Lordship.
the
whether
first
there
marriage
is
will subsist.
And my lord, page 14 of my repetition, my lord.
Just a moment.
তুই জানা divorce section জানা divorce section জানা divorce okay, he says yes, they were not divorced. I am also not sure.
No, should not divorce because the judgment says so.
Not sure.
125, otherwise this, what do you call this, 125 order would have been differently written.
Lordship.
Okay. So in this on contest, you are the second wife. No,
Lordship, if they were not divorced, I do not have a right, Lordship. Second wife do not have a right, Lordship. That I agree, Lordship. But children pertaining to the other benefits which were personal to the that employee, Lordship. Certain rights they also have, Lordship.
but Mr. Sinha, hello. You tell me what can be done. You see, there is a succession in your favor,
Yes, my lord.
correct? You applied for succession on in May 2015.
My lord.
The succession was granted on 21/8/2015.
15 months.
there you don't make the Mr. Bhagwati's kind party. Correct.
My lord.
And prior to that, prior to this 21/8/2015, that is the succession certificate, there's already a order in the 125 proceedings.
My lord.
That order is 9/8/2015. Where your husband accepts the status of Mr. Bhagwati's client as the second wife.
Yes.
Therefore, if the succession certificate is without implementing the necessary parties, where do you stand? That is the first question. The second point is, although you came to the succession court earlier in point of time, few days earlier, but succession certificate was granted to Mr. Bhagwati on 9/8.
2016, my lord.
No, 9/8 to 1995.
No, my lord. As per the affidavit, my lord, the succession certificate, my lord, reflects the date is 8/1/2016.
Lordship.
My lord, page 29, my lord, of their election.
Okay, yes. All right, this is dated
8/1.
8/1/16. That is later in point of time.
Yes.
Lordship.
And lordship kindly see in my repetition, my
And
lord.
here also you don't, you also don't impute them.
Yes. Lordship.
And both of you have not applied before the court for revocation of the succession. So that means there are two succession certificates alive, both contradictory to each other. And when the issues have already been declared by the succession court, how do you expect the writ court to now to adjudicate the matter when the succession certificates have not been challenged? The succession certificate is a judgment which is relevant for the purpose of the declaration of right. Evidence Act. Yes, Mr. Sinha.
My lord.
And Mr. Bhagwati. Yes, Mr. Talukdar.
In respect of lordship, family pension or pensionary benefits, lordship, succession certificate is not applicable, lordship. There is a judgment of this court, lordship. This, his case is governed under Assam Service Pension Bill, lordship, not by the succession act, lordship. The judgment is lordship 2015 4 GLR 571,
Family pension.
lordship, for pensionary benefit, lordship.
You see, we can't do anything about it. Look at the writ petition, page 20. Whether it is right or wrong, it is for a competent court to declare. How in a writ court I will say, you come to page 20 of the writ petition, area pension
Lordship.
included. You also don't approach the trial court for for revocation of this.
Lordship, till that lordship pension paper has not reached to our.
That is okay, but here you see, that's what I am saying. My question is that when there are two succession certificates on board,
Lordship.
one by him, one by the other. Now, if I invoke section 43 of the Evidence Act, insofar as Mr. Sinha's succession certificate is concerned, it is irrelevant for the purpose of Mr. Bhagwati. 43 says so. Irrelevant. But the question is that for you, it is not irrelevant. Both of these succession certificates. Now, his affidavit, Mr. Bhagwati's affidavit, at the running page 61, you will find that pensioner family pension is included here. Now, once a right has been declared by a civil court, and there's no challenge saying that the jurisdiction was not there. Writ petition, how can the issue be decided?
Lordship is as per rule, lordship, first wife will be entitled, lordship. Lordship, but in the
Decree will always override. It will have binding effect. You can't say that I don't follow the decree. Can the accountant general come and say that no decree of the succession certificate I am not following? Can he say so? Once it says, then this decree would be enforced. He said succession is also like a decree; it can be enforced.
lordship, that is as per succession certificate as lordship, succession act, lordship, act, lordship. Lordship, but his pension case is governed under rules, lordship.
No, I understand. But today, if it is enforced, your officer will want to go to jail or he will want to comply with this. What will your officer do?
Lordship, till that, lordship, I am not denying, lordship, because pension paper has to reach our office.
No,
lordship,
it's
we have to
okay.
Verify, lordship.
It's okay, but once it happens, then what can you do? You can't say I don't follow a decree unless you come and ask for preparing to set aside the decree. In succession, it is called revocation of the succession certificate. Unless you apply for that, this is binding. And now there are two certificates. Mr. Sinha, in this case also I'll have to close, I think. Dedicating you to approach the appropriate authority and have it decided.
My lord, sometime will be granted, my lord. I look into it, my lord, and take instruction, my lord.
Because section 43 of the evidence is very clear.
My lord, I understand.
Your degree or certificate or succession certificate, so far as the respondent number 6 is concerned, is irrelevant.
My lord. Sometime will be granted. my lord. I
Okay.
will take
But
instruction.
Mr. K. Sinaran, counsel for the petitioner. Mr. A. Pukan, Lanet, standing counsel for the respondent number 1 to 4. Mr. R. K. Talukdar, Lanet, standing counsel for respondent number 5.
7, lordship.
Achha, for 7. Who is for 5? Achha, Mr. G. Pokhariya, government advocate appearing for respondent number 5. Mr. M. Bhagwati, Lanet, counsel appearing for respondent number 6. And Mr. R. K. Talukdar, Lanet, standing counsel for respondent number 7. Next, Mara. From the materials available on record, it appears that the petitioner, namely Bibi Bala Boisho, had approached the Court of Learned District Judge, Kamrup Metro, Guwahati, by filing a succession proceeding under section 372 of the Succession Act, 1925, on 5/5/2015, in which succession certificate was granted on 21/8/2015. Full stop. The respondent number 6 had also approached the Court of Learned District Judge, Kamrup Aminggaon. Just give that proceeding number, being succession case number. In the first matter, it would be succession case number 54 of 2015. Now, respondent number 6 also approached the Court of Learned District Judge, Kamrup Aminggaon, by filing a separate proceedings under section 372 of the Succession Act for grant of succession certificate. He approached the court also on 30/6/2015 for grant of succession certificate. And the state land court issued succession certificate on 23/12/2015. The debts and securities for which succession certificate in both cases were granted includes pensioner family pension. Sorry, you first write area of pension and pensioner family pension respectively. It is also noted that in the succession case filed by the petitioner, the respondent number 6 was not a party. And in the succession case filed by respondent number 6, the petitioner was not a party. It is also noted that in the meanwhile, the petitioner had approached the Court of Learned Principal Judge, Family Court, Guwahati, in a proceedings under section 125 CRPC, which was registered as FC within bracket criminal bracket use 163 of 1994, and in the said proceeding, the Learned Family Court had passed an order dated, final order dated 9/8/1995, directing her deceased husband to pay maintenance at the rate of rupees 300 per month to the petitioner and rupees 150 per month each for 2 daughters. So in total, rupees 600 per month as maintenance. In the said order, the Learned Principal Judge, Family Court, Guwahati, had mentioned that the husband of the petitioner was having a second wife with 5 children. Next, the Learned Standing Council for the Accountant General has submitted that the pension devolves under the Assam Services within bracket pension, bracket close rules 1969, where succession would not apply. As for answers, submission, a question, issue arises. And if there are two contradictory succession certificates entitling the petitioners therein to pension oblique family pension, where the concerned affected parties are not included. Taking into account that none of the contesting parties have approached the concerned court granting succession certificate for revoking such certificate. Whether it would be appropriate for this writ court to resolve to make an attempt to resolve the issue in exercise of jurisdiction under Article 226 of the Constitution of India, in light of the fact that there are two contradictory succession certificates on record. Next one. In order to enable the learned appearing counsel to address the court on the said point, the matter stands adjourned today. List after ensuing view vacations. In the meantime, you both can talk to each other and resolve the issues, whatever can be granted, because
That
if
would
there's
be a
a,
better option.
if there's a dispute, then we wash our hands. Yes, Mr. Fukan, you have any idea what to do in that matter?
You can, my lord, have a settlement.
No, legally speaking. Legally speaking, the government must have some policy.
I'll look into it. Get back to.
Yes, arrear salary, next item.
Lordship, in this matter, we have given a communication, Lordship, we have received from the department. It's under process, Lordship. The director has written to the concerned DEO, certain documents were not received of the petitioner.
If they don't receive, these people will have to now go to their the house of the petitioner and collect it.
No,
2018 matter.
my lord, I just received this, my lord, instructions.
Okay, where is that letter?
My lord, he's taking it out.
No, sir, okay. Okay. This is how I have seen you after a long time. It's not reached.
Well,
it's not reached. Just read and tell us what is there.
my lord, as far as the with reference to the subject cited above, I'm to say that fresh area proposal as per the prescribed format issued by the finance department after proper verification and calculation of month-wise due and draw and statement along with the non-draw certificate from the DDO concerned, duly countersigned by the treasury concerned for one ward
submission of the same to the government during the financial year 2022-23. Further, he also requested to furnish the following information in respect of the incumbent concerned. The name of the bank, account number, IPSC code number, PAN number of the applicant. This is for your kind information. These informations are, I think, sought for.
We'll give to you, we'll record in the order. Correct. We'll record in the order. You share a copy to Mr. Hawk in his mobile. So they can do it. And insofar as the other requirements are concerned, these authorities will do it in a time frame, otherwise we'll impose, we'll make it clear that we'll impose interest recoverable from the concerned official. Otherwise-
Give us a time frame at least.
No, I'm
3
giving
months,
it, but I'll make in my order very clear
My lord,
that if they don't process it within a time, next
Fine.
day we will pass orders for interest.
my lord.
So it has come.
It's come.
Okay, I'll include this in my order.
My lord.
Mr. Ann Hawk, Learned Counsel for the petitioner. Mr. A. Fukan, Learned Counsel for the Elementary Education Department,
My lord, all the respondents.
appearing for all the respondents. No, no, you.
My lord,
wait a
1,
second.
3 and 4.
1,
3 and 4.
1, 3, and 4.
2 is there. Correct.
Just right before that, Mr. A. Sadia, standing counsel for finance is also present. Finance Department. Next one. The Learned Standing Counsel for the Elementary Education Department has produced a copy of letter number EHA-87/2018/64 dated 19/9/2022 from the Director Elementary Education from Assam to the District Elementary Education Officer Dhemaji regarding resubmission of area budget proposal in respect of the petitioner, namely Tulan Gogoi, from a retired head teacher of Gergeri GERI LP School under BEEO Dhemaji. So the contents of this said letter is as follows. Next one. In view of the nature of query and in the nature of information that is sought for, the petitioner shall, within a period of 10 days from today, furnish to the District Elementary Education Officer Dhemaji the particulars like name, address, name of the bank, account number. Is it IPSC? No.
IFSC. IFSC is most probably.
IFSC, it should be.
IFSC. Typographical error.
So your director needs education.
My lord, wrong typographical error.
IPSC code within bracket SIC should be
SC.
IFSC code. Number, PAN number of the applicant, if available. And if the same is not available, the requirement of PAN number ought not to be insisted. If one doesn't have a PAN number, it doesn't have it.
My lord, sometimes.
It is, the court is inclined to take note of the fact that this writ petition was filed on 14/6/2018. And notice of motion was issued by order dated 16/7/2018. And despite this matter being listed on several occasions, it is for the first time the authorities are seeking information to send a fresh proposal. Stop. taking note of the inordinate delay that the elementary education department is taking to have the retirement benefits of, payment of arrears salary of rupees 1,66,421 claimed by the petitioner for the period 15/5/2015 to 27/9/2016. Now the court is inclined to grant 60 days time from today to dispatch the fresh area proposal for releasing the dues of the petitioner in an error-free mode. No, you just say, just 30 days from today to send it. And the authorities of the elementary education department, including the director of elementary education and the commissioner secretary to the elementary education department, shall ensure that the formalities for all the requisite formalities be complied with within next 30 days and send the proposal to the competent authority in the finance. It will go to finance. Go to finance. For the finance department shall process the claim of the petitioner within the next 30 days from the date of receipt of such proposal. Next paragraph. The aforesaid timelines are given for the purpose that if any authority in the chain causes delay in the processing of the claim of the petitioner, on the next date, the court would be inclined to pass appropriate orders directing the state government in the elementary education department to pay interest to the petitioner with further direction that the state would be able to recover such interest from the concerned officials who are found to have caused delay in the matter. Next, the respective counsel for the elementary education department as well as the finance department shall send a downloaded copy of this order to their respective competent authorities to bring this order to the notice of the said authorities. Next paragraph. Matter stands adjourned for 3 months, awaiting compliance, awaiting appropriate steps to be taken by the authorities based on today's 29th.
29 March.
So making it 28 June 2023.
Yes.
The copy of letter date 19/9/2022 is written on record.
Public.
Mr. Lordship. Probably here it's the entirety infrastructure, Lordship, but today I have
Yeah.
no any instruction.
Okay.
It's happened 2 weeks.
Yes. Is the matter alive?
Lordship, here it has become infructuous because the documents have also been released, but my lords, there is one point where the petitioner has filed a representation for surrender of the seat, my lords. That representation regarding that, my lords, may grant me some time, I'll get an updated result. Otherwise, from what the petitioner has joined the aims, she has got the seat over there, and like the documents has been released from our end. Regarding surrender of the seat of that 2018 entrance exam, my lords, I need to get an updated instruction on that, my.
Make it next week, you then get it by then.
Lordship, I can get the status regarding.
After 2 weeks.
Lordship, after BU break, my lordship.
After due.
Yes, my lordship.
Okay. In view of the nature of claim, both sides are represented. In view of the nature of claim, nature of prayer made in this writ petition from Mr. H. Adyar and standing counsel for the health department shall obtain updated instructions as to whether the prayer of the petitioner to allow her to surrender her seat in MS within bracket ophthalmology at GMC has been disposed of or not. List on. List of view vacations.
Right.
Chief, here in this matter, must say.
Just one moment. Mr. Sharma, in that first item, have you seen the records? No, we'll take up this matter and then take up item 1 again.
Lordship, here in this matter, my senior will be here, Mr. T.J. Mahanta. So he is a big man, so Lordship, matter maybe some recommendation.
Okay. This is item number 7 and 8.
7 and 8.
No, 7 and 8, you're not there.
I'm for APSC also.
Oh, acha. Okay. Okay. Both sides are really represented. As Mr. T.J. Mantal and a senior counsel who appears for the APSC is in bereavement, or the court is inclined to adjourn the matter today. List on 21/4/2023.
Lordship, not 21. I have my December match as marriage as.
Oh, marriage.
Yes.
After 25,
After Eid.
Okay, 26/4.
Yes.
You just write all sides. All sides. You should have taken consent earlier. All the learned counsel was sitting for the entire day.
Yes. I
And
apologize.
when you are taking an adjournment on that gun, it is, they could have left.
Yes. Okay. I apologize.
No, you see, the intention is not to get an apology. The
Yes.
intention is just to inculcate a habit that you should respect the your co-counsel, because it saves so much of time for them.
But we didn't do other.
No, that is okay, but that's why I'm saying apology is not the intention. The intention is that the bar should also understand that this is a relationship which is going to stay, correct? It's a, what you call, marriage of compulsion. Where you have to live with each other, and therefore, why not share the information and make others free, correct? Only that, nothing more. Yes. Mr. Sharma, you got the records right?
I just checked it and. My lord, here, one letter from Hollister High School to the inspector of school. So here, Hamkarna Setri is the headmaster of the Hollister High School. And he has written here with reference to the subject cited above, I have honor to state that the LDA post of Dekargaon is just applied for the post of 88 candidates, but applied appeared in the written test, only 54, and in Viva test, 33, and in computer test, 43 candidates are present, and the panel list has been submitted with this report for your kind and consideration and necessary action. My lord, thereafter inserts affidavit in opposition. The appointment letter of Hem Karna Setri is there. Appointment of supervisor for written test of junior assistant of provincialized
Okay, which page?
secondary school.
Which page?
Annex
Doctor,
B, page 15.
In my affidavit, my lord. Page 15 and excerpt B. That is appointment of the supervisor, Him Korno Setri, as the headmaster of Hollister High School. And the next annexure, my lord, the interview was held at Tezpur Gov High School, SS School, my lord. Annexure C, page 16. It was not held in the Dakargaon High School. It was held in Tezpur Gov SS School under the supervision of the appointed supervisor.
please give that file again. Just send that file again.
Yes.
Oh, nice one. Just right. Mr. M.K. Chaudhary, Leonard, Senior Counsel, assisted by Ms.
And Ahmed.
N. Ahmed,
Ahmed.
Counsel for the petitioner. Mr. You, Sharma, Standing Counsel for the Secondary Education Department, and Dr. P.K. Goswami, Leonard, Counsel appearing for the respondent number
5,
5,
8 and 9.
5, 8, and 9. Next one. The photocopy of the relevant records have been produced by the Ramesh Standing Counsel for the Elementary Education Department.
Secondary education.
Sorry, Secondary Education Department. Stop. In we said record. There will be a reference to guidelines of the Government of Assam, provide memo number GB /EST approval /1/2015 /112 dated Kahiripara 13th November 2015. Next, by the Leonard Standing Counsel for the Secondary Education Department, shall produce a photocopy of the said memo. List on 31/5/2023. Sorry, the 31/3/2023. You get us a photocopy or scan copy of that
Yes.
notification. The records produced shall be retained by the court master. Dr. Goswami, we noticed something. We require that notification to be produced. Continue after break. Yes.
9 and 10, where can they be absorbed today? I am not prepared. I have told the planet friend.
Nine and 10. Okay. Adjourn the prayer with RCCK Council of the Petition. I may have to break your argument and take the bail matters.
Lordship,
If APP is not there,
Lordship.
maybe I'll have to break your argument and.
No problem, issue. My lord. Just a recap, my lord, what had happened. My lord, will only keep that aside for a second, my lord, I will place that. Now, my lord, we are for the Gram Panchayat Secretaries Association.
Yes.
My lord, what had happened was, in this state, there were, my lord, around 663, my lord, Gram Panchayats. Now, this was increased to 2486.
No, you see, that part, I think you have already done on 16/3 when we say Islam submitted. The in sequence till that page 70. I think till there, the matters were already argued.
Yes, sir,
Now-
I'm just
Huh.
giving my lord sequence what had happened. When there was an increase, my lord, to 2486. After that, my lord, around 1707 numbers of secretaries were appointed all over the state on fixed pay.
Yes,
Now, what had happened, my lord? These persons were appointed, my lord, we can say against posts which are not created by the government. Now, the government on 35/2003, my lord, decided to regularize the services of 1707 numbers of government secretaries. Accordingly, my lord, the Jila Parishads, Mahukama Parishads, especially the Jila Parishad, my lord, they issued orders of regularization.
yes,
Now, once this regularization orders were issued, my lord, we come under the provisions of the Provincialization Act of 1999, which was notified, my lord, in 2000. Now, the issue here was, my lord, whether there were posts created to regularize our services. Because, my lord, in the year 1991, my lord, when we were appointed, or even thereafter, we were under the PRI institutions. We were not under the government. We were under the PRI institution, all. And, my lord, if my lord takes up the act, I'll not take my lord to the facts much, my lord. If my lord takes up the act at page 54,
uh,
34, my lord, sorry.
uh,
It's in WPC number 4506, 49.
yes,
Now, my lord, here my lord would come, para 3, it shall be deemed to have come into force on the first day of October 1/3, my lord, 1991.
just a minute.
Now, my lord will have 2B. Date of appointment means the date in relation to any employee, the date on which he joined the services of the panchayat. And D is, my lord, which I'm trying to emphasize. Employees means a person in the employment of the panchayats against regularly sanctioned posts. Now, I was also confusing myself that this is a post which is created by the government. It cannot be, because till the act came into being, the posts that were there were posts created by the PRI institutions themselves, not by the government. Because prior to this act, government had not gone there. These persons were being drawing salaries as authorized by the PRI institutions. Now, my lord would have page 28. Page 28.
It will be difficult to accept your argument because of the fact that if it's a institution where you don't need a government sanctioned post,
Lordship.
Normally, the word sanction post is not used in any parlance.
I'll satisfy your lordship. on that. That's why I brought the second finance commission report, my lord. I'll satisfy your lordship with page 2835 2003. I'm just putting it in perspective, my lord, what had happened.
Yes.
I am directed to convey the approval of the government of Assam to regularize the services of 1707 numbers only of engaged Gram Panchayat secretary as per list enclosed in the scale of pay of so and so. The regularization of service is subject to discharge without notice and without assigning any reasons thereof. This is important. The employees so regularized will be treated as employees of the Panchayati Raj institutions, and they will get their salaries from the respective PRIs. The government of Assam will reimburse the entire expenditure of so and so out of the budget provision under so and so salaries of so and so. The regularization of services will be effective from the date of issue of office order by the CEO of the respective Jila Parishads in this regard. Now, my lord would find the order, one order I have brought, page 30, my lord.
Yes.
In pursuant to government notification number so and so, regularization of services of Gram Panchayat secretary in the scale of pay of so and so plus other as admissible from time to time issued by the order may be effective with effect from 2/6/2003 in the respective Gram Panchayat shown against each list of so and so is appended herein. So, my lord, for the purpose of drawal of salaries by the PRI, paying us salaries by the PRI, posts were created and we were brought in. So now, my lord, we are covered by the decision, by the act at page 34, because the act also looks into things who come in later into the body. We are there, we are regular employees because we are holding a post, and a government post, well, no post until that time was sanctioned by the government. Sanctions came subsequently. Now, my lord proceeds further. Page 35, my lord. What does this mean, my lord? H.
Just a moment, come back to page 30.
Lordship, 30.
What is the point you're trying to make?
My lord, the 30, my lord, I am saying that in pursuance to this, as per the direction given to the CEO, Jila Parishad, they had appointed us, regularized us in each one of those Gram Panchayat where we are, my lord. It is from 2/6/2003. We were all, my lord, posted against posts. I'll link it up, my lord. I'll link it up. Now, my lord would have page 34. And my lord will see 35/2003. The responsibility of payment is on the PRI, like other employees. Now, my lord would come to page 35. What is provincialization? H, my lord. Provincialization means taking over the liabilities of a payment of salaries, including so and so, and such other allowances admissible to the government servant of similar category and gratuity, pension, leave encashment as admissible under the existing rules to the government servant serving under the government of Assam. So there are two parts. Here one says that who are the employees? Employees means who are working against sanction posts, which we are from 2003, if not from before. And provincialization would be, my lord, taking over the services. Now, my lord, comes the order at page 40. My lord.
Yes.
The governor of Assam is pleased to regularize, and this word, my lord, and provincialize. So, my lord, under the act, my lord, I have shown what provincialization is. The services of 1707 numbers of Gaon Panchayat Secretary with prospective effect. Out of so and so, the services of 435 created are regularized against sanctioned vacant posts, and services of remaining so and so are regularized against posts created while dated so and so. The regularization and provision will be effective from the date of joining in the respective places of posting, that is with prospective effect. The provincialization is in conformance with the provisions of so and so and the state government memorandum dated so and so. Now, my lord, what have they done here is they have provincialized our services under the act, but made it prospective.
Yes.
And even when there are sanction posts created earlier by the government itself, those posts also, they said you will get the benefit of provincialization and regulation only from 1/4/2006. Now, my lord would come to the judgment passed by this honorable court at page 42. Para 3.
Because you see, there's also a concept that for the purpose of seeing some benefit, a cutoff date may be given by the.
I'll satisfy your lordship that the cutoff date 1/2/2005 is not attractive in my case. I'm a government servant before that. My lord has seen I was regularized in 35/2003. I was given a post there. I'll clarify that further. Thereafter, on 4/2/2006, they provincialized my services. Provincialization cannot be, my lord, beyond the act. It has to be within the fold of the act. If it is within the fold of the act, I come in automatically. I'm a government servant for all intent and purpose under the act. Then I'm covered by the Assam Pension Services pension rules. Now, even, my lord, in 4/2/2006, they say it will be the Assam pension rules which will be holding the field. The last paragraph. Thereafter, they got, my lord, intelligent and they started doing things otherwise, but that is not proper, my lord. I'll satisfy your lordship. And now, my lord, we'll see page 42. Para 3.
Becoming intelligent is a good trait.
We can also, my lord, this side also can, my lord, develop. The present petitioners approach this court with the help of this petition, praying for inter alia directions to be issued to the state governments to grant to the petitioners regular time scale of pay and also to sanction regular posts to them. In the meantime, the Joint Secretary so and so issued a letter dated 35/2003 intimating all the chief executive officers that the government had approved the proposal for regularization of so and so, plus other elements as may be advisable. On the basis of the communication, the petitioner started receiving salaries with effect from June 2003 and went on receiving the same for 7 months thereafter. But the salary payments were suddenly stopped after January 2004. In the meantime, the official respondent withdrew the financial powers of the petitioner and similarly situated Gaon Panchayat Secretary. Some of those Gaon Panchayat secretaries came to this court by means of so and so. By filing affidavit in the said petition, government took a stand that the services of all Gaon Panchayat secretaries stood regularized on the basis of the letter dated so and so. Accordingly, the writ petition was allowed on 10/6/2003. Means, my lord, the post created by the PRI, we were regularly appointed against that, we were regularized. 4/2/2006 prospectively gave that post. Now, my lord, in that writ petition there was an amendment, and my lord, this 4/2/2006 was put to challenge. That is at para 5, my lord. I'll not trouble your lordship. Now, my lord, what I am on is para 6, my lord. From the report of the second, my lord, will have this one. From the report of the second Assam State Finance Commission published in August 2003, what, however, transpires is that on the date of submission of the report, on the basis of the submission of the report, there were altogether 2390 sanctioned post of Gaon Panchayat secretaries, including 1707 Gaon Panchayat secretaries whose services have been regularized. But as many as 97 posts of Gaon Panchayat secretaries have not been sanctioned to accommodate all the Gaon Panchayat secretaries whose services have been regularized by virtue of the order dated 35/2003 as mentioned. Now, my lord is at this stage. My lord would have the second Finance Commission report, which I have just given. This is the second Finance Commission report, which came in August 2003. My lord would have page 16. 3.2.0, 3.20. I'll come to the table thereafter. In respect of the post of Secretary of 2487 Gaon Panchayats, there are 683 sanctioned provincialized posts. My lord will mark those words, provincialized posts. Additionally, there are 1707 GP secretaries who were engaged at a fixed monthly remuneration of 900, which was subsequently raised to 1,800. It is reported that the services of 1707 numbers of the engaged GP secretaries have been regularized by the respective ZPs. As of now, there are 2,390 sanctioned posts of GP secretaries, including 1707 GP secretaries regularized by ZP. As such, 97 posts are yet to be sanctioned. It is to be noted that the total number of vacancies in the cadre of GP secretaries are 424, which includes 97 posts yet to be sanctioned. So, my lord, this will clarify that we were holding posts, regularly sanctioned posts, not by the government, but under the Panchayati Raj system, which was, my lord, directed to be created by the government, but created by the Jilla Parishads. Now, what has happened? If I can have my lord's attention back at page 7, para 7. Page 44. From the affidavit submitted by the state government respondents, what transpires is that though the services of as many as 1707 numbers of Gaon Panchayat secretaries were provincialized and regularized, adequate number of sanctioned posts neither existed nor created till 35/2003. Now, this is the creation by the government. The requisite number of posts appear to have been sanctioned only by notification dated 4/2006. If the submission of the state respondents are accepted, the petitioners would not be entitled to receive salary for the period 1/6/2003 to 3/2/2006. This apart, the petitioners will lose the benefit of service rendered by them during the said period for the purpose of computation of pension and pensionary benefits. Now, what had happened here was 35, we were directed to be regularized. Posts were created by the PRI. They had created certain posts, my lord, for provincialization, provincialized posts, but not the full. They created those posts on 4/2/2006, but made it prospective. So this period, my lord, 35/2003 to 4/2/2006, it will be a little bit less. This period, we are not being paid the salary that is due to us from the government, because this has to be a government post now. In terms of 35/2003 and 1/4/2006, that with prospective effect is wrong, because you're provincializing my services. So this honorable court finally said, my lord, para 10, considering the matter in its entirety and in the interest of justice, it is hereby made clear and directed that the state government shall pay to the Gaon Panchayat secretary concerned their salaries for the period so and so till the end of so and so, as and when the third finance commission makes necessary provision in this regard. The court accepts the state government to take all necessary steps to obtain such a clearance from the finance commission. The state government is also directed to consider if services rendered by the Gaon Panchayat secretaries concerned between so and so shall be counted for enabling the person concerned to receive pension and pensionary benefits. Now, my lord, here is the catch. The submission of the government was that we will require around 34 crore rupees to do this, and we can't pay them until and unless the second or the finance commission grants us the money. That was the stand, my lord, in paragraph 9. They went to the finance commission and the money was granted. Fine, but then also for that period, 35/2003 to 1/4/2006, I'll be a PRI institution person. I'll not be a government employee. If I may just add, say that, my lord. Because you are saying that you will pay it from the Third Finance Commission. Now, my lord, we'll see what they have done. Page 54.
No, but the previous document you read said that this money would be by way of a reimbursement.
Reimbursement. That's why I'm a PRI employee. 4/2/2006, you provincialized my services. That provincialization ought to have been from 35/2003, but you made it prospective. So if it is prospective from 1/4/2006, then I will be out of the ambit of the old pension rules. But if you are provincializing my services, you are provincializing it under the Act of 1991. If it is provincialized under the Act of 1991, my lord, I will be a government employee existing as on 1/2/2005, and I'll be covered by the old rules. And even 4/2/2006 refers to the Assam Pension Service Rules, the last paragraph. Now, my lord, we'll have page 54. I think this will clear the issue, my lord.
Page
54, my lord. I'll read it slowly, my lord.
yes.
I am directed to say that the governor of Assam is pleased to accord. Manoj has got it.
Yes.
I am directed to say that the governor of Assam is pleased to accord ex post facto approval for creation of 1272 numbers of post of Gaon Panchayat Secretary under Panchayat and Rural Development Department for the period rendered by the GP Secretary concerned with effect from, my lord will note these words, 35/2003 to 3/2/2006. My lord, I'll pause here for a moment. Now, my lord will see they are for like to say creation of, so for the period rendered by the Gaon Panchayat Secretary concerned with 35/2003 to 3/2/2006. Now, these are, my lord, government sanctioned posts being allotted to us, which should have been allotted on 1/4/2006, my lord, when that provincialization order was passed. That was not done on that day. Now they are doing it. They are treating us, they are issuing posts to us from 35/2003 to 3/2/2006. Now, my lord, we'll see the next line, why it was done. The ex post facto creation of the post is accorded in order to treat the services of 1272 numbers of GP Panchayat secretaries concerned as regular service against sanctioned posts for the period with effect from 35/2003 to 3/2/2006. And, my lord, in terms of this, we were given the pay attached to this post from 35/2003 minus what we had drawn back. So now we are holding a government post from 35/2003. And that order, this order, my lord, should have been there in 1/4/2006 itself. But what they do, my lord, why our grievance is the next line. Further, this ex post facto creation of so and so shall not be treated for the purpose of enabling the person concerned to receive pension and pensioning benefits. This is, my lord, wrong. Because if you are provincializing me from 35/2003, I'm a government servant for all intent and purpose from 35/2003. I'll just, my lord, highlight that, my lord, did not go back there. Provincialization means what, my lord? In terms of page 33H, 2H, provincialization means taking over the liabilities for payment of salaries, including dearance allowance, medical relief, and all such other allowances admissible to a government servant of similar category and gratuity pension, so and so, existing to the government servant under the government of Assam. So, my lord, I become a government servant moment I am provincialized. And I have been provincialized initially in a wrong notion of the matter from 4/2/2006. 4/2/2006, madam. Prospectively. But because that is a provincialization order, they realized their mistake and they gave us, my lord, retrospective from 35/2003. So I am drawing regular salary in the government, from 35/2003. And for all intent and purposes, I am a government servant, if not prior to that, from 35/2003. Now, my lord, I'll just like to clarify one thing. Before this notification came, in terms of that second, my lord, pay commission report also, from 35/2003 to 3/2/2006, I was holding a post under the PRI. Moment you provincialize me, means you're taking over all the liabilities. I became a government servant from 35/2003 in pursuance to this. If this be so, my lord, then, my lord, that period cannot be excluded. Because my service starts from 35/2003 now. I'm a government servant for all intent and purpose from 35/2003. I'm a regular servant. And if your lordship goes further, the next paragraph, 1707 numbers of Gaon Panchayat secretaries were regularized and provincialized. White number so and so with prospective effect, so and so, so and so, so and so, so and so remaining so and so were created on 4/2/2006. So this prospective effect is taken away now with this order of 28/3/2018. And I'm a government servant from 35/2003. Because once I'm provincialized under the Act, my lord, as is normal, I'll become a government servant.
Yes.
Now, my lord, the contention that I am raising, that I am a regular employee from 35/2003, my lord, can be further considered. If my lord comes to my reply to the affidavit filed by the respondent number 7, my lord, it was filed on 15/11/21. I'm sorry, my lord, I don't have the running page number. Running page number before I will be here. Page 9 of that, my lord. It's an affidavit filed by my friend Tanay Chakraborty on behalf of one Mr. Deepak Kumar Hazarika.
Respondent number 7.
Respondent number 7, a reply to that one. It's filed on 15/11/2021. It was there on record on the law.
Yes.
Now, my lord would see, this is the assured career progression benefits given to us. 12 years and 10 years and 24 years. In pursuance of finance so and so notification dated so and so and so and so, under the assured career progression scheme, the following GP secretaries are allowed to draw
financial upgradation as admissible along with the date of effect as shown below against each thing. Now, my lord would see one Dhemaji, Sri Dhiren Dhole, my lord, column number 4, date of joining in regular, my lord has got it. Page 9. my lord. Date of joining in regular service, column number 4. 10/6/2003. Now, my lord, when he completes 10 years, my lord would see at column number 8, 10/6/2003. So, sorry, 10/6/2030, 10 years. So, my lord, for all intent and purpose, these are the dates, my lord, 10/6, these are the dates when they were initially regularized in pursuance to 35/2003. Now, it will not lie in the mouth of the government to say. The more value that will be. The more valuable.
Yes.
Now, my lord, this concept of regular service, what it is. My lord will have the ACPS scheme. I've given it earlier, but I think my friend has given a copy also. My lord. It's of 25/5/2011. My lord will have the second page thereof. Clause 4. Financial upgradations under the scheme. Clause Roman 12. my lord. The first financial upgradation under ACP shall be allowed after 10 years of regular service. And the second financial upgradation shall be allowed after 24 years of regular service. Now, this is further clarified in clause 5 at page 5. my lord. Now, my lord would see what this regular service is, 29, clause 29. My lord has got that 29. So, my lord, 2 pages thereafter.
Yes.
Clause 29. Regular service for the purpose of ACPS shall commence from the date of joining of a post in direct entry grade or regular service either on direct recruitment basis or on absorption or on re-employment basis. Service rendered on ad hoc contract basis before regular appointment or pre-appointment training shall not be taken into record. However, past service, regular service in another government department in a post carrying so and so, that's not regular, my lord, required. So, my lord, regular service means a regular service against a sanctioned post in direct entry or adoption or provincialization, if I may bring that concept here. So, my lord, I became a government servant right from 55/2003. Even if my lord says it's a legal fiction, I would say it's under this statute. Now, my lord would see the NPS scheme. That my lord would find at page 38.
Which page?
38, my lord, the regulation. With reference to the above, I am directed to state that the pension liability of the state government has,
Yes.
with reference to the above, I am directed to state that the pension liability of the state government has been rising exponentially. Government of India has also introduced a contributory pension scheme for the employees. The state government is also formulating a similar contributory pension scheme applicable to, my lord, these words, future state government employees who will join the services of the state government on or after 1/2/2005. Future state government employees. My lord, who is joining the services after 1/2/2005? You are paying me my salaries from 35/2000. Now, my lord, in my case, these Gaon Panchayat secretaries, this post is a mandatory post under the Panchayati Raj Act. This post should be there. That my lord would find in the that second pay commission report also, the next page, my lord.
You're getting a salary from which date you said?
35/2003.
35/2003.
Because that is the, my lord, intent at page 58, my lord. Hmm? 54, sorry, my lord. Now, my lord, the whole problem arose because of that 4/2/2006 letter, which although provincialized us, but made it with prospective effect. That was taken away by 54. This is the order, correct order, because once you provincialize, it has to go back. But for that period from 35/2003 to 4/2/2006, or my lord, 3/2/2006, we were holding posts under the PRI. The government under the Act, my lord, took over our liabilities from 35/2003. If that be so, my lord, we are government servants from 35/2003. And we have not entered, because, my lord, after this order at page 54, there is no fresh appointment given to us, my lord. There is no undertaking taken from us. And, my lord, in the earlier round of litigation, my lord will not even find a whisper for this. That because it was there subsequently, my lord, these are developments, my lord. With passage of time, if I can bring in Mohinder Singh Gill here also, my lord, I would have been very happy, but can't. It's an administrative action. But, my lord,
No, I withheld it only because of the fact that the government for any purpose can I've seen a judgment which says that the government can fix a date for implementation.
My lord, you can fix a date, 1 to 2005, no dispute on that. But what does 1 to 2005 says? Future government servants joining service after this date. My case is, my lord, I'm not after that date, I'm already there. 35 2003. My lord, I am just not making it complicated by bringing in the other aspect. Prior to 35 2003, what would happen? I'll make a submission. I have to be there from my date of initial appointment in terms of the act, as well as, my lord, the decision of this honorable court, division bench of this honorable. My lord, Justice Amita Roy's judgment. My lord. I'll make a submission to that at the conclusion. My lord. But I'm only for the purpose of that, I am not covered by this new pension scheme. I'm restricting myself to this 35 2003 argument. Because if you have paid me salaries from 35 2003, you can't say that I'm not a government servant from 35 2003. I'm a government servant for all intent and purpose. Then how can I join the services after 1 to 2000?
That's why they are clarifying that all throughout they are reimbursing.
My lord, that's what I'm trying to distinguish, my lord. 35 2003 is a post creation under the PRI. So I'm holding a regular post. And all those employees who were provincialized under, my lord, the 91 Act were not holding government posts.
You are trying to develop that under that definition of employees,
Lordship.
the sanction post
Would mean, my lord, be sanctioned by the PRI, not by the government. Government sanction will come only when the situation, my lord, at para page 35H comes in. Provincialization. And in my case, it came on 4/2/2006.
Therefore,
But-
you're saying that the post already existed. You were appointed to that sanction post. Thereafter, this provincialization took place, and therefore you have been brought in as a government servant with effect from the date of notification, that is 3.
No, first, my lord, I was brought in from 4/2/2006 because they made it prospective. They did not go back because they should have gone back in terms of the act. But then the cases before this honorable court, subsequently in 2018, they issued a notification. No, we are sanctioning ex post facto approval for this period 35 2003 to 4/2/2016, so that to treat you in service against a regular sanction post. Now, those words, treat me against a regular sanction post, is the provincialization. You have taken over my responsibilities. So I become a government servant from 35 2003. So this period of PRI gets superimposed by this 35 2003. Now, then my lord would see the regular service. If it is not regular service, if it is 4/2/2006, my regular service, then I would have got my first ACP only in 2016, my lord. 10 years. I would not have got it in 2013. I mean, we all the members, my lord. Now, my lord, one last submission. The period of service from my appointed, the date of appointment here, my lord, is not 35 2000. It's the date when I first joined the services in terms of the act and the decision of this honorable. This period from 1/4 or whenever we have joined till, my lord, the date 29/5/2003. This period, my humble submission, my lord, will leave it to the government. Let the government take a decision on that under Rule 31 of the pension. Otherwise, my lord, by following the decision of the division bench, this period automatically comes in. And the division bench is very categorical. My lord has gone through it, I'll not trouble. We are therefore of the considered view that the benefit of provisions of the Act, including those for pension and other retirement dues, would be available to the provincialized employee in service on or after 1/10/91 on the basis of the length of service reckoned from the dates of their initial appointment under the PRI. And I'm not troubling your lordship with that because this is already there. They are bound to give it to me. I'm only praying for a declaration, my lord, that we are there from 35 2003
two things we have challenged before your lordship. 4/2/2006, that prospective effect. And my lord, in the page 54, 2018 notification, communication, the period that this will not be counted for pension and pension event. They can't do that. This. And my lord, in the earlier round of litigation, they had filed an affidavit. And there is a case referred to that, prior to that earlier case, wherein my lord, by filing an affidavit, they said, these are all regularized on 35/2000.
Where is that?
My lord, will have it at page 43. Para 3, last line. My lord, page 43, 1, 2, 3, 4, 5th line. My lord.
Yes, WPC 869.
869. So and so, by filing affidavit in the said writ petition, the government took a stand that services of all the Gaon Panchayat secretaries stood regularized on the basis of the letter dated 35/2003. Accordingly, the said writ petition was allowed on 10/6/2003. And this finding of fact, my lord, I would pray, my lord, is again verified, again fortified from that second Finance Commission report. We are PRI employees at that point of time. No dispute on that. Till 4/2/2006, when we were provincialized. But on provincialization, we are covered by the Act. And it will go back to the date of appointment. And now that you have already created posts from, the government has created posts from 35/2003 to 4/2/2006. We are government servants from 35/2003. This is my humble submission, subject to their reply. Well, I'll submit a written arguments. Little bit correction is there, my lord, on the next day. Whenever it's I'll place that on.
So now you understand. Your own submission is hitting you back. You said
How?
that they become wise.
I don't know.
Today your argument, you have also become wiser.
On the last day. This
Last-
never clicked to me. This clicked only recently. Thanks to your lordship. I think that's the correct position, because I was not being able to reconcile the findings of my lord Justice Ansari and my lord the facts. When I got the second pay commission report, my lord, then only my lord it dawned on me, my lord. This is the position.
Then you have to take back your submission that one can be wiser next.
Yes, always, always.
Yes, Mr. Kaur.
Possibly, other petitions are there also.
No, I think it's covered. Last time they said that they would adopt the argument of Mr. Nair.
Your lordship, in this matter, your lordship, actually, the instruction is that the learned advocate general will appear. Your lordship. So your lordship may kindly let them
Because
finish their
again, it will be same problem. It will be same problem because now I can't have it, now it goes after view because I really
my
can't.
lord.
But these days I'm overworking myself.
Judicial administrative plus, my lord.
It goes after view, but I can't give these days.
Lordship.
But Mr. Kaur, there is a second issue.
yes, lordship.
Nothing stays here. You see the
Yes, your
empty.
that is why your lordship will also submit the requirement. That is submission. After making submission by the learned advocate
So
general.
Whatever I had is also going away.
my lord's notes are there. I will not forget.
It goes after view.
My lord will give a convenient date. But on that day, let them make their submission.
Yes.
Okay.
I'll have my written argument before. If possible, I'll give it before that so that my lord can refresh. Before that.
All sides are duly represented, including Mr. UK Nair and senior counsel for the petitioner, as well as Mr. K. Kumar and the additional advocate general for the state. Most of the submissions made by the counsel for the Learned Senior Counsel for the petitioner is concluded, reserving right to reply on the prayer made by Mr. By the Learned Additional Advocate General. The matter stands adjourned today. In view of the schedules of cases already fixed, there's this matter on 2023.
20, please.
As part of matter.
Lordship. 204. Much of it.
24. 24.
20.
May I please your lordship. My lord, regarding item number 51, my lord, there is one typographical error, my lord, come to my notice today, my lord, regarding the date of retirement in table, my lord, page 7. I may be allowed to correct, my lord.
Which page?
My lord, page 7,
Which petition?
petition number, my lord, 4996 of 2018, my lord,
Page?
page 7. In the table, serial number 4.
Yes.
By Krishna Mohan Chetri.
Hmm.
In the my lord, last column, my lord, date of retirement. Here, my lord, 21/4/1993. It should be, my lord, 31/1/2017, my lord.
No, then you better file an application.
My lord.
So it would be too difficult to make that correction on oral submission.
My lord,
You bring an application on record, the registrate will correct it.
my lord.
You give an advance copy to Mr. Kumar. Because since we have already heard the matter,
My lord.
this is the second time we have been hearing. So not on oral prayer, you make an application.
Highly obliged, your lord.
Obliged, your lordship.
Item number 11.
So the deal matters. Just give a scroll for Mr. SCKL. Advocate SCKL, scroll. Item 11.
But matter may be passed over the time being, my lord. So K go is held up in another court, but he's. I will argue them.
Your lordship, in this item, I am for respondent number 7 on behalf of PG Pukon. Please means the copy of the petition is not served yet to us. Copy of the petition.
No, that I can't do after, if you claim after 5 years that copy is not served, you take a certified copy. After 5 years, you come and say that copy is not served, you take a certified copy.
But they've been made party afterwards, my lord, in. But
11 on
region 20.
Who is made party?
Guwahati University.
Hmm?
Guwahati University standing out.
No, in this, what do you call this?
11/1/2021, my lord, the order dated.
11?
1/2021.
Well, let us see, let Mr. Goway address us. I think this matter can be, I'll see, let Mr. Goway come. Consider your prayer after that.
But as I was pointing out in the morning, if your lordship will kindly have a look at the prayer.
Ah, yes.
It's at page 28.
Yes.
The prayer is to set aside annexures 12A and 12C. That is the first prayer. And if your lordship kindly turns the page, the second part of the prayer is to direct the respondents to allow the petitioner to continue as registrar of NERIS till he attains the age of 62. And if your lordship kindly turns the page 31, your lordship will find
60 years.
he was already 60 years when he filed the writ petition in 2018. And now we are in 23, so nothing remains. I don't know why they are still pursuing the writ petition. And because of this, one would unnecessarily.
In this matter, we've been led by Mr. Arpita Koti, my lord. He is not available today, my lord.
No, he may not be there, but you see, there must be some reason to keep it pending. If you want to be there in service till 62, you have crossed that age now. Your
He's
affidavit-
65 now.
Cross state for fixed, your honor, and my lord can then take it up any day. if
You
not
you are 65.
There was one more issue in this case here, my lord. I've just been told that on the last occasion, my lord Justice A.M. Bujulguda sir had pointed out, it is that respond number 3, 4, and 5 being erased. This court would, this case ought to have been filed before.
Oh, we are not on that at this moment. When otherwise also it has become infectious. Why would we go into all those aspects?
My lord, I think
If
my senior will like to brief on this because probably, my lord, that illegality of the action will survive even though. But I think if my lord give us in some time, my lord,
academic, if you want an academic hearing, we'll excuse Mr. Chaudhary and then fix it for hearing in due course. We'll issue rules.
That is what is creating problems.
we can fix it with short
Your
take,
your
my lord.
lordship is aware, NERIS is a central government funded organization. Because this issue is pending, whether it should be 60, 62, several employees are creating a lot of problems for us. On an infructuous petition, and when we had pointed out, there was an interim order initially, ex parte interim order. The entire interim order was obtained on the basis of a draft rules, which was not even approved either by the Board of Management of the Institute or by the central government. Without pointing out the relevant documents, when we placed those materials on record, the interim order was vacated. And in the meantime, the petition itself has become infructuous. Otherwise, my lord, if they want to pursue it on merits, my lord, this petition deserves to be
No, then-
dismissed with exemplary cost.
Then we make it clear that you take your administrative decision, we hear the matter, we permit you to take a decision.
Today, if he is facing a difficulty of his senior not being present, my lord, let it be next week, my lord, so that the matter can be finished off. It will hardly take 5 minutes. Even if the matter goes into the merits.
Mr. Chaudhary, even an adjournment takes 5 minutes here.
Like, for example, this very adjournment. That
This
is true, my
is-
lord. On occasions, we are also responsible.
That's why I'm pointing to today only, not for any other, only for the day.
In that case,
Uh,
let it be on, my lord, 4th. And your lordship, if it is taken up immediately after, if there are any motion matters, immediately after motions,
Okay.
this will hardly take 5 minutes.
The learned counsel for the petitioner pays for an adjournment. Mr. I. Chaudhary, the senior counsel. Assisted by Mr. V.
Yes, Mr. Kumar.
As Vishwakarma. Appearing for the nearest comma respondent numbers 3 to 6. Has submitted that that as per the prayer made in this repetition. The petitioner seeks continuance of his service till 62 years of age. Mr. V has referred to an affidavit supporting this repetition sworn on 21/8/2018, where the age of the petitioner is shown as 60 years. So therefore, it is apparent that the petitioner is now aged 65 years. Of which the writ petition appears to have been rendered infructuous. Like that. Nonetheless, the learned counsel of the petitioner insists for an adjournment, prayer is allowed. It is made clear that the matter would not be adjourned on the next date of listing. List on 3/4/2023.
4, not if it is convenient. 4, can it be convenient?
No,
Let it be
fixed matters.
4.
No, I have a difficulty. Fourth, we have parted matters.
All right.
Third.
In that
You
case,
may
my
not
lord,
be here.
immediately after the motions, if there are
I
any.
am not saying that, but we'll take it up. Motions I don't have.
One
Parliament.
small fact, my lord.
Yeah, lot. So in pursuant to that direction of my Lord Justice and sir, we had moved an application before the line Chief Justice to transfer that. I'm just been placing it for the fitness, my lord. That application has not been decided yet. Application we have filed.
Varas,
We've been told to file.
You see, I can't issue a direction on the honorable chief justice. Correct.
I'm just been intimidated.
No, it's okay, but I can't do anything about it. Correct.
Oblige, my lord. I'm respondent number 2.
Okay. Also, it's represent question. Because now if you move the matter, he will also observe the today's order. Yes.
Lord, initially, I was appointed, my lord, as stipendary teacher, my lord, thereafter, my lord. Post was created, and my lord, condition was that, my lord, I have to pass, my lord, basic training. I passed, my lord, thereafter my service was regularized. And my service was also confirmed, my lord. And I got salary, my lord, for 19 years. My lord, from 1995 to May 2014. Kindly see first, my lord, page 14, my initial appointment order.
Yes, what is the reason for not paying the salary? Mr. Bora, what is the reason for not paying salary?
It can be taken after some time, Madam, get to the benefit, my lord. It can be taken after some time, my lord. Check the record, my lord, because we have filed an affidavit.
Yes, affidavit is there.
If it be filed by director, my lord, BTC, my lord. And my lord, BTC, my lord, supported my continuation, my lord.
My lord, because he takes in another court, my lord, that's why I have come. It can be taken after some time, my lord. Let me go through the affidavit.
Because you say that it has to be taken up administratively or by the government of Assam. You have in fact supported his case.
15. Whether you must be taking today.
After some time, yes.
Yes, Mr. Patil, so period of regulation of service works.
Yes, what is your stand? Why not from the date of
My lord,
the approval order of 10/1/2005?
but the issue involved in this case is that whether the petitioner is entitled for regularization from the date of his appointment, which is under, my lord, non-sanctioned post, my lord. And in this regard, my lord, a courted bench of our High Court has already decided the issue, my lord. If I may pass, my lord.
No, but you have already approved on 10/1.
Yes, Lord. And the post was sanction post. I can sanction post.
He was initially appointed by the college authority, my lord. It was the internal arrangement between the petitioner.
No. Then you see. Here you come to your affidavit in para 6.
Yes, madam.
In para 6, you say that pursuant to order of this court, the directorate issued the order of conversion of post or so from 10/1/2005. Therefore, this post was already approved. Once you do it, the judgment you are referring to will not apply in your case. Here there was an inability shown that the post could not be created in this judgment which you are showing.
Yes, madam.
Here the issue was that the government refused to sanction the post.
My lord,
And therefore adjudication was made and the court proceeded with the premises that the sanction for the post were not there. And that UGC norms and other things were required to be followed. But in this case, your para 6 is very clear. You have created a post, approved that post. And you see, it is not your case that the posts were not created. Otherwise, you give the benefit from after a few years. It's not that you are denying that benefit. You are giving him that benefit, but after 5 years.
My lord. Para number 8, my lord. Of our affidavit, my lord. Answering the request stated as per the order dated 11/11/2008 passed by the Honorable Court in WBC so this directorate issued a speaking order withdrawing the post conversion order dated 11/1/2005.
Where is
That
that? Where is that High Court order? Where is that High Court order in your speaking order? Where are that?
After that particular petition, there's another petition with page number 50 lodged in my petition. 50 and extra 9.
Conditional appointment.
Page number 53 lordship, paragraph 10 stated regarding this conversion.
This is order 21/4/2009 of the director, which is referred to in page 53.
Yes, sir.
Para 10,
Page 47, Lordship.
page
Page
47.
47, Lordship.
Okay, but then Mr. Gogoi,
Lordship.
now it is clear. By this second repetition,
Lordship.
which is referred here at page
Lordship.
50,
Lordship.
this order at page 47 has gone.
Lordship. Lordship. Lordship.
Then why the petition is not still being accommodated?
Lordship, because there is a, why conversion was necessary, Lordship? Conversion was necessary because, Lordship, there was no sanction post. Originally, the petition is a non-existent post, Lordship, non-sanctioned post, Lordship. There,
Their service was regularized by a Office Memorandum 77/2004 lawsuit. There is a provision in the Office Memorandum lawsuit where there is a no sanction post lawsuit. Then if any vacancy arises in a particular college, that can be converted to the another department lawsuit to accommodate the person's lawsuit. Not particular person's lawsuit, he may be then seniority list of that particular college lawsuit. Even lawsuit if the particular department has and college has not any post lawsuit, then we can borrow from post another college also lawsuit. For lawsuit accommodate the persons who were lawsuit in the list of 356 as per 77/2004 lawsuit. Petitioner was lawsuit regularized as per 77/2004 lawsuit. And there is some condition is stipulated in the particular OM lawsuit. And we are bound by that particular conditions because Honorable Court full bench have said that lawsuit it is a mandatory in nature lawsuit. In Mizanur Rahman case lawsuit, subsequently lawsuit Abdul Wahid case also Honorable High Court says that lawsuit. The persons who are listed in the particular list lawsuit, they are adjusted against the vacant post. If vacant post is not there, the post which was converted from the other department lawsuit. That is the issue lawsuit. Now petitioner is lawsuit regularized. Kindly pay for a moment. Page
Show me that
54.
judgment. Those were not there on record. I don't know.
Wait,
Show me that full bench.
Robin Sharma lawsuit. So full bench lawsuit. If lawsuit gives sometime, I can place all this lawsuit. Remove paper 17. Abdul Wahid judge. Even lawsuit, the page 54 is the lawsuit, appointment order lawsuit. Appointment page 54. My lord, may kindly peruse lawsuit.
No, you see, I had a query.
Lawsuit,
The post was approved for the petitioner from 10/1/2005,
lawsuit,
correct?
lawsuit,
So once is approved,
lawsuit.
then the effect of the appointment should go from that
No,
date only.
lawsuit, no lawsuit. But it was that particular was effect from 2010 itself lawsuit. And petitioner was adjusted lawsuit by way of office order dated lawsuit 24/9/2010 lawsuit. The particular cases Honorable Court decide.
Where is that?
It is on page 54 lawsuit.
Page 54.
Page 54 lawsuit.
Please show me that.
Page 54 lawsuit. The proposed lawsuit.
Yes,
Page 54. CL number 2, proposed regulation is governed as per the provisions of the OM dated so and so lawsuit.
yes.
17/7/2004 lawsuit, appointment assistant professor will be entitled so and so lawsuit. The OM 17/7/2004 stipulates certain conditions lawsuit. That conditions he have to fulfill lawsuit. Now he is seeking the particular period which is lawsuit as a lawsuit non-sanctioned post lawsuit. He was not adjusted. He seeking that particular period should be counted for lawsuit seniority and from the date of 1/1/2005 lawsuit. He's seeking his pair is that lawsuit. Regulation
But where is the order of approval?
order of approval is lawsuit page 54 lawsuit. Page 54
No.
lawsuit.
Approval order is 10/1/2005,
Lawsuit.
Page number 22,
23,
22,
22.
and excerpt 4. On that day, lordship, only petitioner is the only teacher.
Okay, now I get it.
Lordship,
I
the
was-
college authority can claim any post for Department of English in future lordship. It is a conversion lordship as per the OM lordship.
I know where it is. I thought this was the approval order by the,
Lordship. It is a for conversion that particular post is vacant lordship. So it should be accommodated to the persons who were in the non-sanctioned post lordship. Hence, her pair is lordship
okay.
for regulation of service, the petitioner from the post of Geography Department in 10/1/2005 lordship. And
Okay.
petition is
Just-
preferred in 2019 lordship. It is a conditional appointment in page
No, it's,
54.
Mr. Gove, I read it wrongly. Let Mr. Adhikari make a submission because I read it wrongly. I was thinking that this conversion order
Lordship.
of 10/1/2005 is with respect to the petitioner.
It is a conversion order lordship as per 77/2000.
I know that it. So let him make his submission. I did not hear Mr. Adhikari.
Lordship, lordship, lordship.
Yes. I jumped into conclusion that it was the order of approval of the petitioner.
Petitioner was appointed in the 2000 also.
Just a moment, Mr. Adhyapak. Mr. Barwa, you are there as APP in the matter. There are bail applications pending. I'll just take up these two bail matters. in precedence. Then I'll take back your matter.
Item number 16.
May I please allow?
Yes,
In here, the petitioner, your lordship, for 84 days, your lordship is correct.
84 days.
Yes. Earlier, the prayer of the petitioner was rejected by your lordship.
Yes.
But investigation is pending, Lordship, only to collect the medical report, Lordship. Otherwise, Lordship, the investigation almost completely, Lordship. And
You know what is to be done when the medical report is not there. You would have,
still there are 6 days, Lordship, that's why I have completed the investigation. Lordship. We can fix it next Monday, Lordship. Today is the 84 days.
we can't keep him incinerated for long.
But here in your lordship,
You see, why the IO is sitting for a medical report, we don't know. In the medical report, nothing will come out.
Why the investigation part also, which is almost completed.
No,
Lordship.
you look at the FIR and the forwarding.
Why not?
Do you think from medical report, anything will come out?
That may not be, Lordship, still, Lordship,
Then-
to file either search, Lordship, that report will be required. Otherwise, Lordship, there are sufficient material, Lordship has already indicated in the rejected order.
in para 8, your lordship.
Mr. A.M. Khandan, Constable, the petitioner is present. On the prayer made by Mr. R.J. Barwa and APP. Matter stands adjourned today, list on 3/4/2023. Yes. I'm not saying anything, just I'm adjourning the matter.
17.
Yes.
Seventeen.
May I please your lordship? Your lordship, the senior counsel, Mr. J. Roy, is currently on legs, your lordship. Your lordship may kindly pass off the matter for the time being.
Let it be some other day, Lordship, time.
No, because I'll not be able to take up. These are what you call. There are again meetings slated tomorrow. Let us have it today only.
Lordship has already heard this matter, Lordship, only
No,
Lordship
I
directed-
understand, but
Yes,
still adjournment will be difficult. We'll take it up today only.
my lord. March of the.
15. Yes, 15, Mr. Adhyapak. Yes,
So the petitioners appointed by the governing body on 1/1/2000 also. In the regulars,
1/1.
1/1/2000. In geography department also.
Yes,
And thereafter also, the special body, Digboy College, make a proposal before the higher authority to convert one post from Bengali department to geography department. And accordingly, also in 10/1/2005, post was converted from Bengal department. And it was a sanctioned post and vacant due to retirement of Dr. Rothinder Sardar. And thereafter, in 2006, when the managing committee was sent and the post transferred from Bengali department to geography department was converted, trying to convert it in computer science department. And this approval was made.
just a moment. Yes,
Thereafter, the previous order dated 10/1/2005 was withdrawn by the respondent authorities and on 21/4/2009 also. And convert. Against the said conversion concept, the petitioner approached before his court regarding the conversion of the post Bengal department to computer science department.
against, again, no, it was transferred from Bengali to geography.
Next, lordship, same post was converted from Bengali department to computer science department.
Where is that order?
21/4/2009.
Page.
Annexer 8, lordship.
Give me the page.
Forty-seven. Page number 47.
But this writ petition, why was this writ petition 644 was filed? 644, what was that?
Because
Okay, so the matter was sent back saying that the conversion of post, it would not give benefit to the lecturers appointed against non-sanctioned post, correct?
Can you kindly please page number 64?
Just a moment. Which page, Mr. Adhyapak?
64.
Oh.
Because invited Director of Higher Education to the Commissioner Secretary, the last paragraph also.
No, you said that this post was converted to computer. Where is that?
Director Lordship, 21/4/2009 order. Taking order.
That is page
47.
No, this is only withdrawal of the, of that 10/1/2005.
Yes.
No, you said computer, it was converted into computer then. Where is that?
Paragraph number 8 in my petition, Lordship. On 12/9/2006 for conversion of the sanction post of lecturer in Bengal department to computer department, the management committee. Then 12/9/2006 resolved to the Bengal department to higher education son. And accordingly, the previous order was cancelled.
Yes, then what happened?
And Lordship, thereafter, the petitioner filed is petition 6/444/2006. And thereafter, Lordship, the respondent authorities. Respondent to withdraw the previous order, Lordship. 10/1/2005.
No, you refer to the pages, otherwise I would follow you. I'm trying to read it from the documents. Where is your representation?
This was a resolution 12/9/2006 in exam number 6. Lordship.
No, page, give me the page number.
Yes. Page number 26.
26.
26.
What you are trying to show from here, page 26. Well, 9/2006 is that you're adjusted towards another post. You are given post in philosophy.
Yes. But it was not done.
Doesn't help you. But then, Mr. Adhyapak, you see, with all this what you have shown, in contrast to the page 54, which is shown by Mr. Gogoi, your conversion here is from 9/9/2010. You could not have been given what you call effect from a prior date. Because you're not appointed to any post, section vacant post. So therefore, the service you have rendered before the regularization is made, government will not regularize you at no cost.
Page number 56 and extra 12 lots.
Page number
56.
56.
Yes. No, that is the decision of the college committee. You can file a suit and recover money from that. But the government will not make payment to you. This is a resolution of the college. You can proceed against the college, but why against the government? Thereafter, we have made an application before the authority. Page number 57.
No, that won't help you. That won't help you because this appointment, the regularization meeting is always prospective. Now can't be put back. You've got a post from 2010, that is good enough. Otherwise, you could not have been regularized without being regularly selected.
Lordship, today we cannot reopen it, but Lordship, the decision of the government was also violation of the Honorable Supreme Court Constitutional Bench judgment, Lordship. We cannot do this, Lordship.
This could not have been done.
Lordship.
So be
But
prepared
we
what you got.
cannot reopen it, Lordship.
We can't do anything because if I adjudicate, then I'll have to make observation in quoting that Umaderi. This could not have been done. So you're not saying anything, otherwise you lose whatever you have got. This happened because I wrongly read it. But Mr. S.N. Adhyapak and counsel for the petitioner and Mr. K. Gogoi and standing counsel for the higher education department appearing for respondent numbers
1 and 2, Lordship.
1 and 2. Who is appearing for 3 and 4?
Lordship.
None appears on call for respondent numbers 3 and 4. Just correct me on facts if I go wrong. Pursuant to an advertisement dated, advertisement issued by the principal of Digboy College. The petitioner offered a candidature and she was selected and appointed in the post of lecturer within bracket geography on ad hoc basis at a consolidated pay of rupees 1,500 per month with effect from 1/1/2000. Full stop. The governing body of the college by a resolution dated 13/2/2001 proposed to convert one post from Bengali department to Department of Geography. Full stop. The conversion was approved by the Director of Higher Education by a letter dated 10/1/2005. So the petitioner approached this court by filing WPC 644 of 2006. To assess the in the meantime, the post of the conversion of the post from Bengali department to geography was substituted by another resolution dated 4/12/2005 and 12/9/2006. To convert the one post from Bengali department to the post of computer application department, post of lecturer in computer application department. The aggrieved petitioner approached this court by filing WPC 644 of 2006. And this court by judgment and order dated 11/11/2008. Interfered with the approval order dated 10/1/2005. And therefore, remanded the matter back to the Director of Higher Education, Assam, for a decision as to whether his approval dated 10/1/2005 needs to be reviewed or endorsed. So consequently, the Director of Higher Education from Assam by order dated 21/4/2009 withdrew the order of approval dated 10/1/2005. Full stop. The said order dated 21/4/2009 was assailed by the petitioner by filing WPC 2042 of 2009. And this court by order dated 26/5/2010 held that the impugn order dated 21/4/2009 passed by the Director of Higher Education was without authorization by the rules, and therefore the same was quashed. However, with relation to the period for regularization of the petitioner, service of the petitioner was given liberty to file representation before the appropriate authority. Full stop. Thereafter, by an order dated 24/9/2010, the Director of Higher Education, Assam, regularized the service of the petitioner in the Department of Geography against the converted post from the Department of Bengali, giving the date of effect from 9/10/2010. Full stop. The petitioner has now approached the court again by filing the present writ petition, praying for a direction on the respondent authorities to give effect of regularization of service of the petitioner to the post of lecturer in geography in Digboi College with effect from 10/1/2005. Next, for the learned standing counsel for the Higher Education Department, by referring to the stand taken in the affidavit in opposition, has submitted that the relevant orders were passed by the Director of Higher Education in view of the orders passed by this court in WPC 644 of 2006 and WPC 2536 of 2004. And give it serially, 2004 and WPC 2042 or 2009. And it is submitted that as the approval of regularization of service of the petitioner was with effect from 9/9/2010, the Director of Higher Education would not be able to give post facto sanction with effect from 10/1/2005 as claimed by the petitioner. So it is submitted that one cannot be allowed to draw UGC scale of pay while serving against non-sanctioned post. Next paragraph. The court finds that the stand taken by the Director of Higher Education is not contrary to the law because the regularization of service of the petitioner was with effect from 9/9/2010. Full stop. The previous approval order of 10/1/2005 was already interfered by this court. And therefore, the order of regularization could not have been made given effect ex post facto. Without revisiting the judgment of this court dated 11/11/2008. Passed in WBC 6/4/2006. Because the Director of Higher Education had not endorsed approval to his order dated 10/1/2005. But it was a subsequent decision taken by the said authority to regularize the service of the petitioner. Next paragraph. In view of above, comma, court does not find any merit in the claim of the petitioner for giving effect to regularization of her service from 10/1/2005. According to this, writ petition stands dismissed, leaving the parties to bear their own cost.
Congratulations.
So, Mr. Adhyapak, if I give my comment, it will again take back your job.
Congratulations.
Item number 12.
May please your lordship. Petitioner had applied for the post of assistant professor in Assamese department in Pandit Dindayal Upadhyaya Adarsh Mahavidyalaya. The respondent authority have selected the candidates for appointment illegally and to deprive the petitioner. Subsequently, the respondents have filed affidavit showing a new candidate reflecting highest more marks than the petitioner, whereas the said candidate have not got the more marks than petitioner. I have filed an additional affidavit explained detailed. That's it.
When did you file that? It's not there on board. When did you file it?
Lordship,
Oh, yes, affidavit in reply.
yes,
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 it's there.
sir.
It is available.
page number 5, Lordship.
Mr. Gogoi,
Lordship.
2 or 3 days back, we dealt with the matter of same Dindayal Upadhyay.
Lordship, Dindayal Upadhyay in respect of Rajiv Dutt, Lordship has already passed order, Lordship. This is another post, Lordship.
Is not for the
Not
same,
related to
not
this.
related to this post.
After this was issued, Lordship, after another advertisement that was.
Okay,
issued.
okay.
Already Lordship has given direction, Lordship. We have complied. We will comply it, Lordship, and we also comply the Lordship's observation regarding our officials, Lordship. I have already indicated to the authorities, Lordship. I have also, Lordship, given the office also, Lordship.
Lordship, page number 5 of my reply.
Yes,
Serial number 4, Himakshi Bordoloi, General Category, tone 67.28 score, whereas her score should be 63.05.
how do you
On-
say that? On what basis you are saying that?
Lordship, as per CGPA calculation, CGPA in calculation, see, her score should be 63.05. I have explained page number 8, in page number 8. second paragraph, from the second paragraph. Himakshi Bordoloi has obtained marks in PG Assami Arts CGPA 8.38. As per formula to be used for arts, law, fine arts, Guwahati University, as per notification of the Guwahati University, her CGPA should be converted into percentage 5 into CGPA plus 20. After this calculation, 61.90. So percentage of PG should be 61.90 instead of 78.80. Column 13 of comparative statements, which record is available on in the hand of the respondents. Consent.
What is her CGPA?
CGPA.
How much was that?
Her CGPA 8.38.
CGPA is 8.38.
Yes. Okay. As per guideline of the university, page number 12. Formula to convert in percentage.
Where is that calculation you showed? We are showing me just now. Calculation,
Let's see.
this page 8.
Page 8. Yeah, let's see. Let's see.
Okay.
CGPA calculation method guideline, page number 12 of the university.
Yes.
Page number 12, last line, no, last second. From bottom, fourth line, formula to be used for arts, law, fine arts.
Yes. 5
Or
into CGPA plus 20.
Yes, let's see. These formulas should be applied for her.
Okay. But she was given how much?
Let's say, she got a CGPA 8.38.
No, but she was given how much?
She given
67.28.
67.28 instead of 63.05.
Okay.
Petitioner got 66.23.
Okay. So that is your only,
Yes.
that is your only case.
Yes. Okay.
Yes, Mr. Goi.
My lord, kindly paid our affidavit, my lord. Our affidavit, lordship. Affidavit paragraph 4, paragraph 4 is the backup of the lordship vacancy position, lordship.
Paragraph 4 of the
Paragraph 4 of the affidavit,
affidavit in opposition.
lordship.
Yes,
Paragraph 4 is the backup, lordship. Here petitioner is lordship in regarding Amjonga, lordship. Amjonga, there is a unreserved post 2, lordship, and 1 for OBC, lordship. And Bihali also he is claiming, lordship. Bihali, lordship, 2 unreserved post and 1 OBC or MOBC, lordship. Total 3 posts, lordship.
just Amjonga,
Amjonga, lordship.
here,
Here 2 posts is reserved for unreserved category, lordship.
yes,
And 1 post is for OBC, lordship.
yes,
Total 3 posts, my lord. My lord may kindly note it. My lord. And then lordship Bihali also 2 posts for unreserved and 1 for OBC, lordship. Then my lord may kindly come to lordship. Paragraph 8, lordship. Paragraph 8,
just a moment.
lordship.
This is Himakshi. Where is her name? Himakshi Bordole is,
Himakshi Bodole's name
In
is lordship
Dalgaon.
in Amjonga, lordship.
yes,
Paragraph 8 of our affidavit, lordship. And Himakshi Bodole's name is reflected in page 6, lordship.
yes, so she was selected but not appointed.
Lordship, she was not appointed, lordship, because to the less enrollment, lordship.
Okay,
Even lordship, her candidacy is rejected, lordship. Then persons will come in the unreserved categories, lordship. Number 6 and number 7, lordship. Number 7 is Ankur Datta, lordship. And petitioner position is 8th position, lordship.
Ankur Datta is respondent number?
No, he was not made a party here, lordship.
Okay,
Only Himakshi Bodle has made a party because lordship 2 posts is there. 1 post, lordship Vinita Das is appointed, lordship.
okay,
In another post was recommended Himakshi Bodle. So my friend has lordship implemented her. Complete question, I think. And lordship, although allegation was made, lordship, against particular Himakshi Bodle, she was also not made party here also, lordship.
okay.
The basic grievance is against Himakshi Bodle and she was not made party here.
But
And
otherwise also, she did
Otherwise
not get.
also it's not in the considered zone, lordship.
But Himakshi Bordole name comes again page 5 also.
Page 5 also, lordship. Page
So somebody was above her, she has joined.
lordship. She was not
Okay,
there. In Dolgaon, lordship. Dolgaon unreserved 2 posts is there. Bhushita Medi and Sima Bhuya is lordship appointed, lordship.
okay.
And paragraph 9, lordship, it is very specific, lordship. Paragraph 9 we have stated, lordship. Paragraph 9, if my lord permit, I can read,
Yes, yes.
lordship. The deponent begs to state that Dr. Pranab Kumar Kolita claimed for appointment assistant professor Assamese Department in Amjonga, lordship. There are 3 posts of assistant professor Assamese department in the college, out of which 2 posts for unreserved and 1 post for OBC candidate. In the meantime, 1 post of unreserved has already been filled up by Vinita Das, and the post of OBC has also been filled up by Devendu Hendik, OBC candidate, and 1 post of unreserved is vacant. College authority has submitted proposal for appointment of Himakshi Bodole against the unreserved post, which is pending due to shortage of the enrollment of the college. Dr. Pranab Kolita cannot claim a selected candidate to the post of assistant professor Assamese Department Amjonga, as his position is 8 in the college. On the other hand, the validity of the selection list has already over in the month of June 2018. The government so by letter written 15/5/2018 accorded permission of filling up the post, lordship. Again, lordship, due to the lapse of the time, lordship, 1 year period, we have directed the authorities to, lordship, re-advertise the post, lordship. That was done, and it is also covered by recent judgment of the Honorable Apex Court, lordship, where one of the authorities, our my lord Justice S. Roy also there, lordship. If lordship permit, I can test that judgment also.
Where's that judgment? You are Mr. S. Burman.
Yes,
Then we can't do anything because she has not been selected.
Maxi Bordoloi was not selected at the time of filing the writ petition as per record, page number 36 of the writ petition. She was not selected. At the filing of the writ petition, respondent had filed the affidavit showing Himakshi Bordoloi. They are going to appoint. Considering
we are not
all the
saying-
facts and
That is not the stand.
We are not saying that.
That is not the stand. This is reflected here. This is not,
Yes, we are-
she has been selected but not appointed because there's a less amount of teachers. So that is what is there saying.
Less employment, even lordship, the validity of the particular
List has
select is
gone.
also less lordship. And
So this Himakshi Bordoloi doesn't get anything.
lordship.
Mr. Burman, we are dismissing our petition then.
Lordship.
Lordship, I had placed two judgment lordship, one I have relying paragraph 6, where my lord, our research is there lordship, that judgment is paragraph 6 lordship. And another judgment lordship, in paragraph 14, I am relying lordship,
Okay.
paragraph 14 lordship.
Para 6.
Para 6 lordship. Even lordship here, petitioner's name is not included in the select list also lordship.
Heard. Mr. S. Burman on counsel for the petitioner.
Lordship, look, Lordship. Meet it and another day.
No. Once we have heard it,
So I will prepare this.
no. After hearing, we can't adjourn it. Mr. S. Burman, on counsel for the petitioner, and Mr. K. Gogoi, learned standing counsel for the Higher Education Department.
Only Lordship.
No. After hearing it, I am not adjourning. Why should I spend time if I have to adjourn it?
FX as a part hard, Lordship.
No. Why should I give it pattern? I hardly have anything here. You see the shine? It will show nothing is there, nothing
At
stands,
least,
nothing sticks.
one more time,
No.
may be given an opportunity.
No. Once you have heard it, I have heard it. The case of the petitioner, the petitioner claims eligible to be appointed in the post of assistant professor in Assamese department. First off, the petitioner submitted his candidature for 4 colleges, i.e. Pandit Deen Dayal Upadhyay, Adarsh Mahavidyalay is one, at Amjonga within bracket Gwalpara, Dalgaon within bracket Darang, Tulunjia TULUN GIA within bracket Bongaigaon, and Bihali BIHALI within bracket Biswanath. First off,
May please your Lordship.
the petitioner projects that he has fared well in the selection process. And that in the selection process, the other successful candidates have been favored depriving the petitioner of selection and appointment. So it is posited that the corresponding authorities are in the process of publishing a fresh advertisement to fill up the remaining posts of professor in Assamese in the said 4 colleges. This Pandit Deen Dayal Upadhyaya Adesh Mahavidyalaya, you just write within bracket PDUAM for short. Next paragraph. Learned counsel for the petitioner took pains in projecting that for the purpose of calculating the what is this called? Score? What score is it called? Mr.
CGPL.
No. That score is the abbreviation for that. The score of 70.24 and this 66, 68. What is the score? There is a name,
Which is the marks obtained by interview, Lordship.
but there is a name for it.
Lordship,
There is a name for that.
Lordship,
Score in interview.
Lordship, score interview. This is the score interview, Lordship.
The second pains to refer to the score obtained by the various candidates and referring to one of the candidate. Comment is submitted that the methodology of calculating CGPA score into percentage is prescribed by the Guwahati University, and the formula to be used for arts, law, and fine arts in respect of CGPA up to 9.5 would be within bracket 5 into CGPA bracket closed plus 20 semicolon. For CGPA above 9.5, it would be within bracket 6.5 into CGPA bracket close plus 5.50 is 5.50. Page 12, Mr. Gogoi,
Lordship,
page 12,
Lordship.
it is 5 into CGPA plus 20. Second is 65.
65 into CGPA minus 550, Lordship. 65 into CGPA, Lordship.
Okay.
Minus
For
550,
CGPA above. No, but that would be too large a gap.
Lordship.
65 into CGPA. And in the first, it is 5 CGPA.
Lordship.
The gap is it not much?
So, Lordship, now the university modify it, Lordship. So, if at present, Lordship, that's used, that notification is not exist. Now they have changes it, Lordship.
Okay, 65 into CGPA minus 550.
Lordship.
Minus 550.
Minus 550.
Okay, minus 550.
Above 9.5.
Semicolon, for a first class, minimum CGPA will be 8. Semicolon, for second class minimum, CGPA will be 5. So accordingly, it is submitted that the particular candidate whose name is not being mentioned in this order would have been $61.90, but the said candidate was awarded 67.28. Accordingly, they submitted that there were mistakes in calculating the score awarded to various candidates. Accordingly, the learned counsel for the petitioner has pleaded for a direction on the respondent. Accordingly, this petition is filed under Article 226 of the Constitution of India, with a prayer that the respondents be directed to appoint the petitioner as assistant professor in the SMS department of PDUAM. Next paragraph. The learned standing counsel for the Higher Education Department has made its submissions to justify the non-selection of the petitioner. Next paragraph. The in this case, the learned standing counsel for the Higher Education Department has demonstrated from the affidavit in opposition filed by respondent number 3 that the distribution of post of professor for SMS department in the concerned colleges were distributed as follows. Viz. Vigilant. Number 1, for PDUAM Tulungiad, comma, one post was for unreserved category and the other post was for SC, and 2 candidates were under the said categories were appointed, and other 3 candidates out of the remaining 3 candidates for the said post, comma, one candidate in unreserved category was not selected. So in respect of PDUAM Behali, comma, there were 2 unreserved posts and 1 post was reserved for OBC, out of which 1 unreserved category candidate had joined. And the other 2 selected candidates under unreserved and OBC category did not join. However, they were given they were given respective choices to join PDUAM Dhalgaon, DLGON, and PDUAM Amjonga. In respect of PDUAM Dhalgaon, the post was for two unreserved and 1 OBC category. Where 1 unreserved category candidate was appointed, and another candidate who was otherwise OBC was selected as unreserved category, and a 3rd candidate was selected as OBC category. In respect of PD UAM Amjonga. Comma. There were 3 unreserved posts. And 2 posts reserved for OBC category, out of which one unreserved candidate was given choice to, who did not join was given a choice to join at PD UAM Behali. Another unreserved category candidate was appointed. The other OBC candidate was also given a choice, did not join and given choice to join at PD UAM Dolgaon. Insofar as the candidates whose score was stated to have been wrongly provided, was a candidate for PD UAM Amjonga, was selected but was not appointed due to shortage of students enrollment in the subject. And one selected OBC category candidate was selected and appointed. So therefore, it is noted that in respect of unreserved category, the unreserved category candidate who was selected and appointed had scored above the petitioner who was the petitioner had scored 66.23 as unreserved in unreserved category, whereas the 2 persons on unreserved category who were offered appointment had scored 70.24 and 67.67 respectively. First of all, we also take note of the submissions made by the learned standing question for the higher education department that as the appointments could not be made within the validity of the select list of the validity of the select list, comma, which is 1 year, comma, the authorities have decided to initiate a fresh selection process. Next paragraph. We also note that although the petitioner has issued, petitioner has filed his writ petition for a direction to appoint her in the post of professor, assistant professor in SMS department. But the petitioner has no vested right to be appointed, and the respondent authorities have a right not to fill up the post, because in this case they have demonstrated that that one post could not be filled up due to less number of students. Full stop.
May I please your lordship, kindly one sentence. I may submit. Lordship, in 2019, they had filed affidavit saying appointment due to shortage of students. In 2020, they had published an advertisement inviting application to fill up the said post.
That's what I've said. I've said in an order that they want to re-advertise. So you see, in college X, there may not be a student in a particular department in 1 year. Next year it will be filled up.
Already stay order exists.
So that goes because a student may come and then they have to be appointed.
I maybe what preference.
So in this regard, we may refer to the decision of the Supreme Court of India in the case of Employee State Insurance Corporation and another versus Dr. Vinay Kumar and others. 2022 live law within bracket SC 514, where it is held that a candidate who has applied does not have a legal right to insist that the recruitment process set in motion should be carried to its logical end. So under such circumstances, the court does not find any merit in this petition, and therefore this petition stands dismissed. There shall be no orders to cost. Next para, it may be noted that an interim order was passed on 10/9/2018 to keep one post in general category in PDUAM at Anjunga to be kept vacant, which was effective till the next returnable date. It said interim order was extended by order dated 3/10/2018 till the next returnable date. But thereafter, there is no order to extend the interim order.
There is an order in IA also. And a stay order in IA also. IA number 61/20.
61 of 20. Okay. So the said order was again extended. The order dated 28/1/2020 passed in IA Civil 61 of 2020. Full stop. The said interim orders would stand vacated. Will matter. I may not take up any other matter. This will- Other matters would be adjourned.
Your Lordship,
Item
Lordship,
number
pertaining
18
to
and
item
19.
11, your Lordship, CIT, that is Central Institute of Technology. Earlier days, your Lordship, when my senior is assistant SDI, he is handling that matter, but now he is no longer.
It's okay, then it's your internal arrangement, how you do it. But then you inform the President CGC, but the court can't do anything.
Yes, your Lordship, I will inform the present one. Your
Today I can't take up the matter.
Lordship. Kindly, my senior name may be struck off, your Lordship.
No, you'll have to file a memo to that effect. We can't do it. Once you appear as a counsel, I can't do it unless you bring out record. You must comply with this rule 65 of
Yes,
the
Your Lordship,
chapter 5.
inform
5A.
present one, your lordship.
All matters will be adjourned. I'll take up
Deeply
only the
organized.
bail matter.
Item number 18 and 19, it is a long matter is pending from this since 2010 onwards, related to central exchange matter. If it may be tomorrow, day after tomorrow, that can be disposed.
No,
of.
before vacations, we are not taking up any hearing matter. Because if it is a tax matter, it takes some time.
Yes.
It goes after vacation.
Yes.
You
Kindly my
give a
presence
date
will-
after vacation.
Kindly my presence may be recorded.
Those will be matters will be adjourned only.
Yes, sir.
I am not passing any orders. It'll just be adjourned.
3-5.
3-5.
3-5.
A tax matter.
Deeply organized.
18-19.
There is one partner matter, item 17, bill matter.
No, that's what I have called. Bail matter I have called.
Item number 14, my lord.
It will be adjourned. You will take a bail now.
Lordship, this matter was partner, lordship may take up tomorrow or maybe any other.
No, 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 no.
I don't know, my lord.
Because
One
then,
year, 13 days. he
because
is going
then
to-
I will-
I'm not saying that, my lord.
no, because if I adjourn it, that's why I'm taking up. Because if I adjourn it, then I release it and then it will be.
Lordship will not release it, keep it partner, my lord. Lordship will take it tomorrow, my lord, I'm saying that.
No, I can't take it because I have part matters tomorrow.
Then day after tomorrow, my
No,
lord.
no, no, no. You know what
Today
is
I have some
coming.
difficulty.
You know what is happening. I hardly have time.
Today I have some difficulty, that's what I'm saying, my lord. I
No,
would
no.
not have taken it at this stage, my lord, if I.
No, no, you see, earlier adjournment would have been okay, but now at this stage.
This has come after a long time, my lord. I'm not saying that, I'm taking this. as
No,
today's
but I
opportunity.
don't have time. Every day I have meetings and all. I hardly go.
I understand,
Stay
my lord.
home.
I'm not saying that, my lord, but what I'm saying that, my lord, lordship today, my lord, it's at the fire of, my lord, I have some. Otherwise, I would have done, but if you don't come in the time, my lord. I'm stuck up in other courts. I have got meeting also, my lord, attended. Your lordship knows, my lord. Because of the 75th celebration. Not frame of mind to argue today, my lord. Lordship might make it tomorrow, any day, my lord. I'm not saying that.
No, it can't be handled.
The lordship will be third or fourth, my lord.
Tomorrow it's not possible.
Fourth,
It's
my
not
lord.
possible. Third. But do it in the first half.
My lord. Third, my lord.
You take adjournment in any other court.
Then lordship may take it at 10:30 also. I am not.
Third,
I'll be out.
you will be out of session. I see.
Already, matters are already heard. It is neither a prison nor a civil case nor a malor kill me appeal. Bail matter, 1 year and 13 days. And as per the court's order, my lord, there are 16/3/2000. I will show it, my lord, everything, my lord, for the records, what's happening actually. For the IU within 7 days. He didn't appear, he didn't cooperate last time. My lord, I will show from the records what's happening, my lord. Not only that. When the informant went, he's a lawyer, my lord, to police station to inquire about. On the way, he was threatened by them. Near Kukrumara. FIR is filed, that is received by the police. Yes, my lord, kindly see for the 438 conditions, subsection 2, 1 and 4. If you violate the, then it is to be cancelled. There is no forgiveness. This is the nature. I will argue, my lord, my case, my lord. Bail, exit bail, that in criminal case, he must be aware and conscious. Lordship will take it on fourth, my lord. He cannot show the Haryana power here.
See, my difficulty is that I am unable to manage time. Every day is we have so much of.
Time.
Then we are fixing it on 31st.
My lord.
But you have to do it in the first half. You make both of you come together and then
Let it be at 10:30, Joseph. 10:30. 10:30, Joseph.
you make a mention, we'll take it up. At 10:30, we'll take it up.
My lord.
I'm in my order, I'm not fixing at 10:30, but you make a mention, we'll take it up.
My lord, first half, my lord. 10:30, my lord.
10:30.
Yes.
Uh,
31st, my lord. I'm over.
So,
Parts of it.
Mr. J. Roy, Senior Counsel for the petitioner, Mr. R.P. Sharma, Learned Senior Counsel for the private respondent, informant. And Mr. Ajay Barwal and the PPR is present. With the case diary.
With the case diary, Lordship.
On the prayer made by Learned Counsel for the petition, Senior Counsel for the petitioner matter stands adjourned today. So. List again on 31/3/2023.
But liberty may be granted to mention.
On the said date, the matter would not be adjourned at any cost.
No, Lordship will say liberty may be granted to
So
mention.
you
it.
make a mention. I know that because I'll be taking the bench. It will be listed in my court.
We'll be attentive here, madam.
Liberty to mention would mean that mention for adjournment.
No, not that. Actually, madam, sometimes at 5 o'clock for doing a matter, your Lordship knows the difficulty by now.
My lord, I.
Why is anxiety? Understand why is anxiety? I will
Is
place those submission, my lord, at appropriate time, madam.
Is this time not a happy time?
My humble
Is it not? It's a happy time.
Anyway, my lord, we'll,
What is the correct language?
uh,
Happy hours.
happy hours.
So
I'll make submission, my lord, with that.
But Lordship has already heard this matter. He has already submitted, Lordship. Nothing has to be, nothing is new, Lordship. And Lordship, I only rely on the case diary, Lordship, and IO has filed objection. That I'll place, Lordship. That must, Lordship.
Always welcome, my lord.
And so far, my lord, waiting up to 5 weeks, my lord, let him learn something from me, I teach him. How to be up to 11.
Much of that.
My friend has more excitement, my lord.
no. Something to learn from that. Once he said that, you take 5 minutes off and listen to the theory. I think you will love it.
3:30 in the morning to 11 at night, continuously.